Welcome back, Acting Chief Justice.
Thank you, Chairperson. Thank you, Commissioners.
Are you ready? Can we
Yes,
get
I'm
the
ready.
ball rolling again? Thank you, Acting Chief Justice.
Thank you.
Commissioner Matola Hlepu.
Good afternoon, Chief Justice.
Good afternoon.
Acting Chief Justice, sorry.
Please.
I want to take you back to a priorities that you gave us in the morning. I do know that the judiciary is structured in terms of the law. The hierarchy and all that you have to. It's an act of parliament and all those things. But in a sense, I still feel that as much as it's structured that way, succession planning, succession plan, I don't see it within the judiciary, and which I think maybe we still have to look at that. I'll tell you why I'm saying that. You spoke about the PECs and the NECs, and you said you keep them in place. They seem to be working. But some of us who are stakeholders in those NECs, we feel that a lot has to be done for those, Some of us became part of those structures, but we still feel that there's no monitoring. We discuss issues, and we are not given feedback. And for me, when we go there, people tend to be justifying certain things, and there's nobody who tells us from our last meeting, this is what we have done, especially public works, especially other departments. Everybody is actually justifying certain things. So I think if you can just elaborate on that. And secondly, on the succession planning, because you are not part of, as a Deputy Chief Justice, you are not part of all those structures, you seem to be at a disadvantage. You rely on the heads of court to tell you whether things are happening or not. So don't you think, as Justice J.P. Tlaleti said, you should be part and parcel of everything that the Chief Justice does? What's your take on that?
No, thank you, Commissioner. I think the question you raise about maybe the PEECs in general, or maybe a particular PEEC, is quite an important one, because it's important when we have structures in place that are established in order to achieve certain objectives. It's important that we monitor how they perform their work, how they are performing, and whether they are successful or not. Because if they are not achieving what they were meant to achieve, we may have to reconsider or see how they should be changed. So I think what you say is important, but I think I would have expected that the chairperson of the PEEC, every PEEC, who is the JP, that he or she would have the responsibility to make sure that when you meet today, after you met last month, you look at whether the things that you said last month must be done by A, B, C have been done, and if they have not been done, what's the explanation? So I think that that's very important, but I would expect that from the chairperson of the body. So, but one of the things I have in mind is that if I am lucky enough to be appointed by the president, I would want to go around and meet various stakeholders and get their feeling about where challenges are. As I said, I have heard from JPs in the different provinces. I think the only JP I didn't speak to is the Western Cape one. Well, I didn't speak to the Gauteng JP, but I spoke to the AJP. And generally speaking, the reports they gave me were that the PEECs are working well. In some provinces, they work better than in others, but nobody said they are not working. They said there may be some challenges we need to fix here and there, but overall they are working. So my suggestion is that that is something that I would encourage you to raise with the JP to say, let us make sure for every meeting that we look at what had been asked of certain people to do last time to see what progress has been made so that we don't end up with a lot of decisions that have been made but have not been implemented. So that would be my suggestion. With regard to the DCJ not attending the NEEC because he would be at NEEC level rather than at PEEC level, I have no doubt that if it was not for the fact that I've been in the commission, the former Chief Justice would have asked me to be part of the NEEC. So I think the reason why I have not been part is largely because I've been in the commission. If I am appointed, I will be able to get in quite involved.
Thank you. The second input I request from you on your priorities, you spoke about, I know that you have your LLM in patent law, and you really are passionate about making sure that black judges and practitioners, they get chance to practice actually in those fields that are reserved for our white colleagues. I just want you to expand, especially on the part of practitioners. What did you have in mind when you said that? What do you have in mind? How are you going to do it to make sure that you encourage those things?
Well, there may be a need for more discussion about what we do, but what we all know is that when it comes to certain branches of law, the clients that have got that kind of work are companies in the private sector, and most of them are white-owned. So it's a question of how do we get this work from them. You might not get much patent law work from the state, from government, I would imagine. So we need to see what we can do about that. But one of the ideas that has crossed my mind in this regard some time back is this, whether in terms of procurement legislation, whether we should not consider, or government should not consider, including as one of the factors, if you are going to get government work, proof of how much of your work gets given to black professionals, maybe black lawyers, women, it may be accountants, black accountants, women accountants, and other professions where blacks are excluded. It may well be that that the government should consider that, to say, if you can show that a certain amount of your work, legal work, is given to black practitioners, women practitioners, in order to advance transformation, you should get certain points about that. Of course, we must continue to encourage the private sector not to look at transformation as something just for government, but that they should take part in it because it's good for the country. Some years back, I was involved in a certain initiative to try and get some companies to give some black law firms work. We went a certain way. We got a black lawyer to go to their legal department and stay for 3 months on the basis that after that they would then give her work, and then they would get another one to also go there. So after some time, we would have X number of black lawyers who would have stayed at that legal department and come out and be given work. But somehow, after some time, they seemed to lose interest before they could complete the whole process. That is the company now. After that particular black lawyer had worked in the legal department of that company for I think about 3 months. During that period, they would pay the black practitioner about salary. Yeah.
The last one, Acting Chief Justice. I know you are a champion in labor, you know, and you know how mediation works. It's such a tool to actually to have matters being settled. I just want you to maybe to expand on your idea. You haven't said much about access to justice. Maybe you may have missed it. How can mediation actually, and the rules of mediation be fast-tracked to make sure that certain disputes are resolved by way of mediation? You know, I'm just thinking of intergovernmental disputes, you know, and political party disputes, maybe EFF and ANC, they can mediate and they don't have to go to court. You know, can you just expand on that?
Well, access to justice is a very important topic, of course, and there are various components to it. With regard to mediation, my experience with mediation is that a lot depends on the commitment of the people concerned with mediation. Let me make you an example that demonstrates what I'm talking about. You know, in the 1980s, when I started getting involved in labor law, what was called the Labor Relations Act of 1958 made provision for conciliation under Section 35, that in regard to labor disputes, there must be conciliation first before the dispute could go elsewhere, whether to court or to a strike and so on. That system of conciliation, which is for all intents and purposes the same as mediation, really, it's different forms, ended up almost collapsing and not working. And the parties just went through the motions and didn't, simply because they were forced to go through it. They never made an effort to resolve disputes. And then there was an organization that came up with a mediation service. Maybe some of the commissioners might remember it. It used to be called IMSA, Independent Mediation Service of South Africa. I think it was chaired by Charles Newpen, if I'm not mistaken. And they went around getting employers and employers' organizations and trade unions to buy into the idea of mediation on a voluntary basis to see its benefits. And after some time, they had gathered enough stakeholders who were prepared to use mediation, and they used private practitioners and so on, and I was one of them. I was trained in mediation. I did mediation and arbitration. That service, that mediation service, was very successful. It was very successful. The understanding at the time was that its success lay in its voluntary nature. Actually, they were even paying for it, employers and trade unions. And the buy-in for them was that the mediators were people that they had confidence in, that were put on the list. So we might have to work a lot in getting various people and stakeholders to really see the value of mediation so that it can work. That doesn't mean that it can never or should never be forced, because that has its place as well. But it's important that we should look at trying to do more to popularize it.
Okay, I think I was part of IMSA, I think, and we used to, besides LIBA, there was community-based mediation, which were very successful. So I was just thinking along those lines, that a lot of disputes that come to court can actually be mediated.
Yeah.
Thank you.
No, I think that can work too. Community mediation, there's no reason why it can't work. Actually, mediation can work in lots of things. It can work with neighbor disputes. It can work with community disputes. It's a question of having people who are prepared to run it. Maybe in a locality, in a neighborhood, in a section, in a township, or whatever. If people have disputes, they know that there are these people who can be contacted because they are mediators and they can mediate and resolve issues.
Thank you, Acting President.
Thank you, Commissioner Mtolo-Zlepio. Commissioner Magwanisha.
Thank you, Acting President. Good afternoon again, Acting Chief Justice.
Good afternoon, Commissioner.
We are currently dealing with the cannabis bill. So
we're
hoping that that smoke, when we pass it, we will see it. Unfortunately, we can't. Maybe we'll see it on Zoom. I got worried, Acting Chief Justice, when you said that you would not go back to the issue on the language policy. I got worried because one of your colleagues has made a judgment in Sikos, and I thought that it was a good thing to do. So, if there will be no champions for that, I got a little bit worried.
Well, the two are not mutually exclusive. The question about language policy is more about what language to use officially in proceedings. As I understand, Justice Meyer did that judgment in isiXhosa in circumstances where I think argument would have been in English, but I don't know, I don't have the details. But you can have English as the official language of record for the proceedings. That's the language in which the proceedings will be recorded. But you can still decide that I will write my judgment, for example, in isiZulu. Let us say, for example, both parties are Zulu speaking, so I could decide to write it in isiZulu, and then of course I would think that I would provide an English translation so that they are both there. I applaud Justice Meyer for having done that, because she has done better than me. I've been meaning to do one in isiZulu for some time, but haven't got around to doing it. Thank you. But part of the reason why I said I wouldn't go back is it's just discipline to say my view did not prevail. I shouldn't, if I get appointed as Chief Justice, and say now I must reverse a decision that was properly taken. I must respect decisions that don't go according to me, and accept them and implement them if the majority agrees with them.
No, thank you very much. As the chair of the commission, that is the Zondo Commission, and in terms of the PP, Public Protector Remedial Action, you assumed responsibility and accountability for the operational costs of the commission, even if you delegated those to the secretary. Now, can you just briefly tell us, just to clarify this, did the commission use 1 billion or 2 billion?
No, it did not reach 2 billion. I think the amount is around 1 billion.
Secondly, along those lines, I would want to raise this question because it is linked to your oversight as the Chief Justice, potential Chief Justice, over the administration. That will be the Office of the Chief Justice. In 2018-2019, 9.6 million was paid for private venues for the commission, the Zondo Commission. It escalated to 11.2 million in the following year, and then it dropped to 2.2 million because a decision was taken to use public facilities. Now, my question is, why did it take 2 years to arrive at that decision, which saved taxpayers money, serious money?
Well, that's a fair question, Commissioner. When the commission started, I think the officials from the Department of Justice who were assisting, we discussed the issue of venues, and they said that preference for commissions is given first to using public venues such as municipalities. So I said, no, that's fine. They said they only used, if I recall correctly, private venues if they could not find appropriate or close by venues that are public venues. My recollection is that they spent some time going and checking at venues, including municipal venues. They came back to me and said the municipal venues that they had been looking for either were not available or were not in the right conditions. But they, as far as I know, they tried to get public venues but did not succeed. So when later on, then they were stuck with a private venue. But once an opportunity came to go to a public venue, that's what they did.
Now, if we were to fast forward, the president appoints you, you retire in 2.5 years. An ordinary person, how would he describe your court, your jurisprudence? Judge, the former Deputy Judge Mosenega, in his book, All Rise, he will talk about the Chaslaxon Court, the Mohoeng Court. How would you want to be remembered? How would you want to be remembered by ordinary people as to what will be your court?
Well, I wouldn't want them to call it Zondo Court. I would leave to people what they call it, but I wouldn't like them to call it the Zondo Court. My interest is to serve, and hopefully, if I serve well, and I'm not so interested in labels. I hope I'm not missing your question.
No, I don't think we understand one another.
Oh, okay.
I know that you're not interested in the name, but how would you want your legacy to be remembered? As what do you want concretely? I mean, you have been very detailed about what you want to achieve, but I think in a very summarized way for our people, what would you want to, I mean, what I could concretely say is that you are more interested in the institutional model. Is that what you would want to be remembered for only?
Well, I would put it this way. I'm not so concerned about how I would be remembered, but I would be concerned that I made a contribution And that issue of institutional model, I think, would be important to the judiciary. But I would just want to know that I made a contribution. And if people associated that development, that achievement with me and remembered me in the context of it, that's fine, but that would not be uppermost in my mind. But in terms of what I would want to do, certainly that is one of the things that I would like to do. But not so much because I want to be remembered, but simply because I think it's an important thing for our judiciary to have.
The last one, for the purpose of consistency, I have asked almost all the candidates, what is your view with respect to prosecutors and state advocates acting as judges?
So far, there has been a concern about them acting as judges. I would have that concern. I must say that it may well be that somebody might put argument that I haven't heard before that suggests that it should be fine, but my understanding is that we have for a long time always wanted to get people who are independent, private sector, or magistrates. But as I say, maybe I haven't had recent argument as to why maybe that approach is old-fashioned, so I would be prepared to listen to argument.
Thank you, Acting President. Thank you, TCJ.
Thank you, Commissioner.
Follow-up,
For follow-up, please.
Thank you, Commissioner Magwanisha.
Follow-up.
Commissioner Mlambo.
Thank you, Acting President. Acting CJ, are you aware of the march which we organized to the Commission demanding that you change the venue to a public venue? We even left a memorandum. One of the reasons indicated in that memorandum was that one of the implicated journalists was actually working in that building. And we said, you need to change the venue, not only cost, but also that there are people in this venue who are implicated. And secondly, are you aware that Mashaba, when the commission was announced, Herman Mashaba was the mayor in Joburg, who repeatedly made public announcement that he's got facilities available for the commission to use so that it doesn't cost the taxpayers a lot of money.
My memory is not very clear, Commissioner Malema, but I seem to think I may have been aware at the time of maybe a march or maybe a call. I do know that at some stage there were concerns in the public about us using that venue. Well, what I recall now, what I still recall is that it was more about costs, but it may be that your memorandum went beyond costs, you know. So I don't have a recollection of reading your memorandum, but what may have happened is that your memorandum may have come, and those calls may have come at a time when we had already committed ourselves to a contract up to a certain period. That's what I can think now. I can't remember then. That's what I can think, that if we had already committed ourselves up to a certain period and we decided to leave before the end of that period, that might have been a breach of contract and there might have been damages and so on. But certainly I think the Department of Justice would have officials who I hope would confirm that when we were going to look for the premises and they did the looking, I didn't, they at least told me that they had gone to municipal offices and elsewhere to try and get a public venue.
Thank you.
Thank you, Commissioner Malema. Commissioner Dodovo.
Thank you very much, Deputy President. Good afternoon.
Good afternoon, Commissioner.
SJ. Yes, you did a wonderful job at the Commission, and what is coming out very clear is that there would be a lot of prosecutions emanating out of that particular process. And I'm following the question that Honorable Magwanisha was asking. And the way I see it, I'm quite concerned about the quality of our prosecutors. If you've done such a work, and those who are on the wrong side of the law are to be prosecuted, and you don't have strong prosecutors, state law, state advocates, and so on, what is going to happen with those cases? If the accused contracts Advocate Madonsela or Advocate Mpofu, it means we are in trouble, and therefore will never come to know the truth or the perpetrators of the alleged acts of corruption, state capture, whatever that is, are not going to be prosecuted, are not going to be answerable for the deeds that they have committed. What is your take on that, and how can that be coordinated with the prosecution to ensure that that area is given the necessary attention?
Thank you, Commissioner. Well, you touch on the prosecutions and the NPA. That has reminded me of the fact that I have been in touch with the National Director of Public Prosecutions to try and understand what is happening, what is the state of the NPA is insofar as they may be affected by the operations of courts, and there may be delays and backlogs and so on. And in a note that she sent to me, one of the challenges that she mentioned in relation to the NPA was, I think, precisely the point you make, namely that there are certain crimes, and I think he referred to corruption crimes. I don't know if he referred to the State Capture Commission, and said that in certain cases, these cases of corruption require people with certain expertise and experience, and sometimes they don't have those people. I guess what she may have meant is they don't have them in enough numbers, maybe, yeah. But the note said that there are those problems. And it got me thinking to say, so with the mountains of evidence from the Commission, maybe they will be overwhelmed, and it might be difficult. I even thought whether they should not, and maybe they are already doing this, they should not talk to lawyers in private practice, Advocate Mpofu, Advocate Madonsela, and negotiate deals with advocates who have got those skills, that experience, in terms of which those lawyers could charge at a lesser rate than their normal rate, but they could have work over a longer period. So the fact that they would be involved in that work over a longer period would compensate for the lower rates that they would be charging. But they would then get the skills. And I thought that they could say to those lawyers, when you think about the lower rate that we are asking you to charge, remember that it's also your way of contributing to South Africa with a lesser rate of corruption and so on. It's your own contribution to making the country a better country for your children and children's children. And it may well be that lots of lawyers might be prepared to compromise on their rates and be available. I mean, I know in the commission, some of the lawyers we had were prepared at a certain stage when there seemed to be no money available. They said, DCJ, we will not abandon the commission. We will not abandon you. This commission is very important for the country. We will see what we can do, but we will, even if we are not charging because there is no money, but we can't leave this commission at a time when it has not finished its work. So there may be a lot of lawyers who would be prepared to make certain sacrifices for the sake of the country, but there would need to be some discussion. Yeah.
Follow up.
Thank you, Commissioner Dodovu.
Follow up, Acting President.
Honorable Minister.
Yeah, no, thank you very much, Acting Chief Justice. On the question of Commissioner Dodovu, I just want to confirm that indeed in terms of Section 38 of the National Prosecuting Act, I will read it for the benefit of the public. The engagements of person to perform services in specific cases. 38.1 says the National Director may, in consultation with the Minister, and the Deputy National Director or Director may, in consultation with the Minister and the National Director, on behalf of the state, engage under agreements in writing persons having suitable qualifications and experience to perform services in specific cases. I want to confirm that indeed that has already been the case where we have approved for the National Director to engage, and I think they will still come with more requests.
Okay.
And to also confirm that we have also raised the fact that the engagements must be sensitive to the demographics of the country. So that it's not just a group of senior white practitioners. It must be sensitive to the demographics of the country. But also in terms of the data center, maybe that is what you may want to share with the Commission, that it will migrate to the department which can then be used by the entire criminal justice system, which I think it's one of, despite the report, it's one of the biggest legacies you are leaving the criminal justice cluster with.
Yes. No, thank you, Minister. That is true. We are leaving the country with really a very important equipment which will be very useful in fighting crime. So it's very important. But I'm encouraged by what you have read, Minister, and I'm encouraged that something seems to be done to address the matter. Thank you.
Is that it, Honorable Minister? Thank you. Commissioner Klaba.
Thank you very much, Acting President. Mtiane, good afternoon.
Good afternoon, Commissioner Klaba.
Thank you very much. I would put these questions to you because they have been put to the other candidates. The first question is, do you subscribe to the convention that judges speak through their judgments?
For a long time, it was said that judges speak through their judgments and in no other way. But I don't subscribe to the view now, at this day and age, that judges only speak through their judgments. So I think they do speak through their judgments, but at this day and age, in our constitutional democracy, they also give lectures, they also make speeches. They must just be careful and sensitive on the issues on which they talk.
And avoid certain controversial or areas that may land on some controversy.
Well, they must try and make sure that they bear in mind what is permissible for a judge and what's not permissible.
Thank you very much. There were concerns about you calling a press conference to deal with matters arising from the statement of the Minister of State. Are you aware of them?
Yes, I'm aware.
Thank you very much. Now, upon reflection, Mtiane, do you still think that it was an appropriate platform to voice the concerns of the judiciary?
No, I still think so, Commissioner Klaver. It was, in my view, quite a disciplined way. I was careful about what I said, and before I said it, I consulted heads of court, and the heads of court included my 3 colleagues who are also candidates here. I consulted the heads of court to say, there is this article, should we respond? What do you say? What do you feel about it? And I consulted justices of the Constitutional Court, and the overwhelming response was that there must be a response. This is unacceptable. And once that I'd received that, I then decided that I would proceed. But I was clear in my own mind that I did not want to get involved in a lot of points that Minister Sisulu made in her article. I would want to restrict myself to what we considered to be an insult to the judiciary. So when I spoke, I made it quite clear that it is not our position that as judges we should not be criticized. I made it clear that I accept, and we accept, all of us as judges, that we can be criticized, but we took the view, and it's not just me, that unfortunately Minister Sisulu had included insults in her article against us. I think it was justified in all of the circumstances.
Thank you very much, DCJ. Some critics think that a statement, a press statement, would have been sufficient to deal with the issues, as you have correctly, stated.
Well, as I was explaining to Commissioner Nojesi, initially I thought we would issue a statement, but I was very busy with part 2 of the report, and the statement was just taking too long to be completed. I don't know whether you have had this experience. Sometimes when you draft something, sometimes you draft something one time and it's ready. Sometimes you have to draft 3-4 drafts before you are happy with what you draft. So the statement, the article had already been in the public domain for about 5 or 6 days. So I realized that I was going to take too long. Maybe it was going to be only out the following day. That's when I decided, look, let me just deal with it in the way in which I dealt with it. But I'm satisfied that it was justified to deal with it in the way I dealt with it, but I accept that somebody else might have just dealt with it in a different way. But as the acting head of the judiciary, in that situation, I made a judgment call.
And you confirm that there was no malice involved?
No, not at all, not at all, not at all, yeah.
Maybe-
I never said anything about Minister Sisulu that I would consider was insulting to her. I didn't insult her back. I just pointed out what I pointed out.
My last question, DCJ. Having been in the office of the Chief Justice since 2012, I think. 2015.
Having been in the Constitutional Court from 2012.
Office of the CJ
Or being DCJ from 2017.
from 2017.
Yeah,
Okay.
June
No,
2017.
Thank you very much for that correction. What has been your experience of the relationship among the various arms of state?
Well, the relationship among the three arms of the state is not always the same. Let me start with the judiciary and the legislature and parliament. I think the speaker will confirm the judiciary and the parliament and legislature, as far as I am concerned, really have never had any tensions. We have given judgments where we said the parliament maybe acted in breach of their constitutional obligations, but as far as I know, they have accepted whatever decisions and there have never been any tensions. And when we went for the tea break in the morning, Madam Speaker, they greeted me, we greeted well. I think there are no tensions, but with regard to the judiciary and the executive, there are tensions from time to time, but I think those tensions are inevitable, and I think all of us, both the executive and ourselves, accept that sometimes there would be those tensions. Sometimes the tensions may be influenced by different events in the country that happen. But I mean, like the time when, I think in 2015, the former Chief Justice asked for a meeting with President Zuma when there had been attacks on the judiciary. I think there were certain tensions. So I think that there is an obligation on both us in the judiciary, particularly in the leadership as well as the executive, to try and put the country first, put the people first, and make sure that we work together, but accept that sometimes we will have different views on very important issues and there will be some tensions, but it's healthy tensions.
So in other words, you confirm that tension would be inherent in the nature of the responsibilities assigned to the different arms of government.
Yes.
And there has never been tension fueled by personalities, in your view?
I'm not aware. I'm not aware of any that could be because of personalities, but it's not impossible. But I'm not aware.
Thank you very much. It's something that can be avoided. If
Yes,
there was
yes,
Thank
yes,
you very much,
yes.
Acting
Yes.
Chief Justice. Thanks, Acting President.
Thank you, Commissioner Klawe. Commissioner Nyambi.
Thank you, Acting President. Afternoon, Acting Chief Justice Zondo.
Good afternoon, Commissioner.
As you are aware that since Monday was spoiled for choice, people from serious humble beginnings, different villages and townships in South Africa. Justice Madlanga coming from Jinjini, Mlambo Mjindini, yourself, Iklopo, then Justice Maya Zondo. Those are historically disadvantaged areas. But when it comes to the issue of access to justice, you have courts that don't start on time on Friday. Some people are leaving early. Those challenges that you know. What is it that you think can do to those seriously historically disadvantaged areas that are still struggling to date, yet we are enjoying democracy, if you can be given the opportunity to be Chief Justice?
Thank you very much, Commissioner. As I indicated earlier on, it's going to be important. It would be important that if I am lucky to be appointed Chief Justice, that I engage with all stakeholders to establish exactly what can be done with regard to various problems that are there which impact negatively on access to justice. I would not be starting afresh because, as I said this morning, I have already been in contact with various people within the judiciary who have shared with me what challenges there are in various courts, high courts, regional courts, district courts, and I would not leave out courts in rural areas and townships because those courts are very important and they must be given attention. So my approach would be to try and establish, get a good audit of what the problems are. I already have a good idea, but to say, okay, what needs to be done, and try and make sure that those challenges are addressed in whatever way they can be addressed.
Thank you, SCJ. When you were presenting the vision, looking at the role of a CJ in a constitutional democracy, as well as striving to have a functional, efficient, accountable, and independent judiciary, you were very clear that, of course, you are not perfect, and to err, it's human. You made some mistakes. And I totally agree with you. Probably anything that you think you can single out with hindsight that you think you made a mistake in your responsibility.
Can I confirm generally or in relation to a particular position?
As a judicial officer.
As a judicial officer. Well, I assume that giving a wrong judgment would not fall under that if you are set aside on appeal.
Definitely.
It falls under that. No. Or it doesn't? Or,
yes. It's because, maybe let me explain a bit.
Yeah.
I'm asking this question because I want to understand, because I'm aligning myself with that vision.
Yes.
But I want to have a sense that it's not just a lip service.
Yes.
You are acknowledging that,
Yes.
of course, that is why I said
Yes.
in hindsight.
Yes. Well, there isn't one that comes to my mind immediately, but that can't be because they are not there. It can't be because they are not there. They must be there, and maybe they are not few also. But maybe it is simply because I'm sitting on this seat. That's why I can't remember them. The moment I leave this seat, I might remember them. But I'm sure I've made mistakes. I might not remember them now. There's no way that I think there's no way that you can be a judge for 25 years, as I have been, and you haven't made some mistakes. I just can't immediately remember.
It's fine. The third one, from your vision, you touch the issue of intellectual leadership And even some bodies like CASAC, they've made it as part of serious issues to be considered, of course. So if you can elaborate about it so that we're on the same page, and what's the value that we can attach to it?
Well, the value for it is that the adjudication of cases, particularly at the high level of the constitutional courts, is the adjudicative value is immense. And you, as the leader, as well as other justices of the Constitutional Court, have to be able to grapple with sometimes difficult and complex cases. And as a leader, you must be able to lead. It doesn't mean that you must always be right. It doesn't mean that others can't disagree with you, but you must provide that leadership in resolving complex cases. For example, as Chief Justice or as Judge President in a High Court or Labor Court, Labor Appeal Court, or as President of the Supreme Court of Appeal, as far as I'm concerned, it is expected that when there is quite a complex case, you take it as the leader. You don't lightly give it to somebody else. Obviously, you have to give other people opportunities according to their level of experience and so on. You might not need to take all those cases yourself, but you are supposed to lead. This might not be concerned with intellectual leadership, but it's also important in terms of leadership. Another example is that if there is a case to be heard in your court, which could produce an unpopular decision, my view is that as the leader, you must take that case and say, I'll take it, rather than give it to your colleagues. You are the leader. You take it. If you are going to give a judgment that's going to be criticized, somebody must be unpopular, let it be you, the leader. That's what leadership is about. You mustn't look at the case and say, hey, this is going to be inconvenient or difficult. It might make me unpopular. You shift it to somebody else. No, that's not leadership. That's my belief of leadership. So in terms of intellectual leadership, that's what you do. You give me a chance by asking about this question to refer to an article that I would have loved to have referred to earlier, but I didn't because it wasn't here. You know, in 1987, that was my first year after finishing my LLB, 1987. I was doing articles. I'd moved from Mrs. Mtlanga's office to a white law firm because Mrs. Mtlanga had been assassinated about 2 years before. I wrote an article which got published in the Industrial Law Journal on a topic that falls within labor law. It is called Forum Shopping, the Industrial Court versus the Supreme Court, 1987, in the Industrial Law Journal. There I picked up an issue which continues to be controversial to this day, more than 30 years later. I dealt there with the question of the relationship between the jurisdiction of the Industrial Court in dealing with labor matters and the jurisdiction of the then Supreme Court, to say when do matters go to the Industrial Court or when do they go to the Supreme Court in the context of dismissals and evictions. It had been inspired by the first legal strike in the mines that had taken place, I think, in 1985 or so. And I raised that issue. As we speak, more than 30 years later, there are a number of judgments in our courts, including the Constitutional Court and the Supreme Court of Appeal, which are still dealing with the question of when do you go to the labor court or the high court, because sometimes people can characterize their case as administrative action and therefore they say they want to go to the high court. But somebody else might say, no, but this is a labor matter, you should go to the labor court. So there are those judgments. So I would like to indicate that I was able to identify something that seems to have continued for many years, which still occupy us.
My last issue, it's an article written by retired Justice Mbuyiseli, the one that you spoke about earlier. It's aware about what is going on today. It's saying the new Chief Justice must have integrity, fierce independence, sound understanding of legal theory and our society, empathy for our people, and outstanding intelligence. It's saying choosing an administrative experience over intellectual excellence may be a way to contain judicial independence. I invite your comment.
Well, a number of those things that he mentioned there, which he says are things that you must look for when you are looking for a Chief Justice, I agree with. I guess you want my comment on the last part.
Exactly, I'm interested in the last part. Choosing administrative experience over intellectual excellence may be a way to contain judicial independence.
Well, I won't comment to the extent, because you said he is aware of what is happening. If he is relating that comment to these processes, I wouldn't comment, but I can imagine that under certain circumstances you could have a situation such as that.
Thank you, Acting Chief Justice. Thank you, Acting President.
Thank you, Commissioner Nyambi. Commissioner Muima.
Thank you, Acting President. Good afternoon, Acting Chief Justice.
Good afternoon, Commissioner.
Let me start by expressing my appreciation in terms of the manner in which we were able to navigate, given the mammoth task that the President gave you in terms of the commission, because as you correctly pointed out, it was the commission of the Presidency in terms of the public protector as endorsed by the Court.
Yes, thank you.
The question that I want to pose relate to the convergence of views that all the Concord judges had with the 2016 March judgment on the Ngandla around the need to intervene when there's a sense that the executive arm of government has dropped the ball. How do you apply the concept of the supremacy of the Constitution and also the values like the rule of law, accountability and rationality in that judgment?
I'm going to ask you to repeat the question, Commissioner. I'm sorry, when you were speaking, there was some noise that came from this side. I think I missed some important parts. I'm sorry about that.
Thank you, Acting Chief Justice. The question that I want to pose is, how do you apply the concept of the supremacy of the Constitution and the values as enshrined in the Constitution, like the rule of law, rationality, transparency, and accountability, applying it to the Nkandla judgment, where there was a convergence of views by Concord judges that the executive has dropped the ball?
Of course, when you talk about the supremacy of the Constitution, you are talking about the supremacy of everything that makes the Constitution. That includes the values that you are talking about. The court had to particularly look at the issues of accountability in that in the Nkandla judgment, but as it happens with most of these matters, you don't look at one. You normally have to look at a number. You find that they interrelate, or at least some of them. So part of what was very important in the Nkandla judgment was accountability. You will recall that it was not just the executive which had dropped the ball, also Parliament had dropped the ball, and the court pointed that out. So accountability was very important, the rule of law was very important, and a number of other values.
Thank you, Acting Chief Justice. Let's take that further. In 2017, you dissented when the majority of judges said there is a need to instruct Parliament to make rules to be able to impeach the President by virtue of the same judgment that you agreed upon in March 2016. Thank you. Can you just explain the difference?
Are you saying the difference between, well, when you were speaking, I was thinking of my minority judgment.
Exactly. That's why why did you dissent?
Okay, no, thank you, Commissioner. Now I understand. Well, you see, in law, there are various principles that apply in different circumstances. You know what the majority said in that case, and I didn't agree with the majority. My approach, and the approach of those who agreed with me, was that before any party that serves in Parliament can approach the Constitutional Court to resolve a particular problem that relates to Parliament, they should first show that this is a matter that can't be resolved in terms of the arrangements and procedures that are internal in Parliament. In other words, my view was, please don't rush to us if you do have a mechanism within Parliament which you can use to resolve this matter. Only come to us when you have exhausted that. If you have not exhausted that, at least tell us why we should allow you to come to us without exhausting that. If you can't tell us, my view was go back. That was my view. But of course, if Parliament, or if they told us, no, but it won't work because of ABCD, then we would examine that ABCD and see whether it justifies them coming to the Concord, the highest court in the land, directly. But in that particular case, there was no explanation really, as far as I recall. And this was also a case where the opposition parties were not able to say, we knew that the ruling party was going to use its majority to block our views, because in that particular case, the evidence showed that there had been other meetings where issues had been discussed and agreed upon. So there was no reason to think that if they had continued with the processes, internal processes, they would have been frustrated. Actually, in that case, my recollection is that the speaker or deputy speaker said that in the particular committee, those parties had said they wanted to go and consult their principals and they would come back, but they didn't come back. Instead, they went to court. That's my recollection. And my principle, my judgment was simply based on saying, exhaust your own internal arrangements before you come to court, because you might resolve this matter and it might not need to take our time.
Thank you, Acting Chief Justice. The last point now relates to the observation that one made with the Concord judgment that led to the July incidents last year. The observation is that I want to put forward is that in most cases the legitimacy of the court is important, and its independence is sacrosanct, because the judiciary is our last line of defense in terms of defending our constitution. But when a decision is taken by a court that to a certain extent is interpreted to have been outside the tolerance level, in most cases there will be, it will trigger a political attack on the independence of the judiciary. And that attack necessarily will lead to the institutional weakening of the judiciary, and that is not in the interest of our constitutional democracy that people have fought for and that people have died for. So, given that the lessons from the 2015 of the meeting between the Speaker, the Chief Justice, and the President, is there no need to probably have the same conversation, because what happened in July last year was unprecedented. And what is it that has to be done to educate, particularly from the judiciary side, the executive side, and the legislative side, to educate the public about the legitimacy and the importance of the judiciary as institution that is our final arbiter in defending our hard-earned democracy. Thank you.
Thank you, Commissioner. Well, I don't think that we, as the judiciary, and I include myself as particularly part of the leadership of the judiciary, that we have done enough to educate people about the judiciary, maybe about also the different arms of the state. I remember many years ago when I was still judge president, at one of the heads of court meeting, we had made a resolution. We had made a decision that we should even have members of the heads of court speak on television to try and explain certain things to the people about the judiciary, its role and its role in democracy and so on, and in radio stations and so on. But unfortunately, I don't think it was implemented. But I would imagine that all of us owe it to our country and to our people to educate them about structures of our constitution, about the importance of the judiciary, the importance of parliament, the executive and the relationship, the importance of the courts and so on. So I think that as leadership of the judiciary, we should revisit that issue. I think there's a need to educate our people.
Thank you, Acting Chief Justice. Thank you, Acting President.
Thank you, Commissioner Muiman. Commissioner Lucas.
Thank you very much, Acting President. Good afternoon.
Good afternoon, Commissioner.
Comrade Zondo.
Good afternoon,
Chief
Commissioner
Justice
Lucas.
Zondo. I've said it to JP Mlambo and to President Maya.
Yes.
It's very strange to find that someone that you are sitting on this side with all the time is on that side. But I think that will not take away from the fact that it is a very important process. And also that the candidates that are sitting here is aspiring to actually sit in a very high position in the country as one of the representatives of one of the state of the arms of state. So you should expect sometimes that we will ask questions that you will not be happy with.
Yes. No, I accept that completely.
And we are also not here to please anyone. Not that I want to ask you any funny questions. I just want to put it as a fact, because even if it is reported what we are doing inside here, it seems as if when we woke up this morning, we decided we will have a personal fight with any candidate that is sitting here in front of us. We don't have to. We respect each other, and we all have a responsibility because we have been deployed to make sure that we execute this very important task. Now, I know this question has been asked to you, but I am not totally satisfied with the way you have responded on this one. I still want to know, taking into account the fact that you said inclusivity is something that you want to strive for. Now, for me, inclusivity goes to the fact that it can never be business as usual. If we say we want to make sure that we have a judiciary or even a magistracy or one judiciary that will understand what we want to achieve in this country. And I'm asking you the same question that I ask some of the other candidates. How do you envisage, particularly, remember there is also the issue that time is not on your side. And although you said that 2.5 years is neither too long or too short to achieve whatever you want to achieve if you have a clear vision of where you want to take the judiciary. Now my question is, how do you envisage to build a cadre of judicial officers right from the grassroots level up to the Constitutional Court, that is the apex court, that will understand that we are supposed to serve the people of South Africa, and that will understand that we need to give service with empathy and also to make sure that justice is seen to be done to those that are not necessarily having access to justice. That is my first part of the question. Secondly, you have elaborated very extensively on how you have lost women in the process of trying to start to bring about equity within the labor court and labor appeals court and so on. How will you be able to make the judiciary a place where women are felt appreciated and that also they decide it's a career of choice? You know why I'm asking you that question? You said as soon as you have capacitated a woman, they are snatched by this court and that court and that court. Isn't it because mostly they are appointed as acting and they didn't at that stage have that kind of security that they needed? I'm just thinking. But how will you make sure that women and other groupings, like someone spoke here about LGBTIQA, but others that were not necessarily taken with, like men was, it seemed it is a given in the judiciary, if you are a man, something will happen for you, but not necessarily for other groupings. Now you said you just want to be remembered that you also contributed. We don't want you just to contribute. We want, if we select you as a Chief Justice, after 2.5 years, we should say, wow, it was worthwhile, even if it was just this short space of time. What is your vision with regards to this question that I just asked you now?
Thank you, Commissioner Lucas. When I said I want to contribute, it didn't necessarily mean I didn't intend that you should say, wow.
We also don't want it to be business as usual.
No, I accept that. All I sought to emphasize, Commissioner, was that my focus in whatever I do would not be and is not about what legacy I would leave behind. That's the point I was making. Well, Commissioner Lucas, the challenges that I experienced in the Labour Court and Labour Appeal Court trying to retain judges and women judges as well was due to the fact that it was like the heads of courts higher than my court would wait until I identified women that had potential and gave them an opportunities in my court. And they were waiting, then they start seeing them in my court and start seeing their judgments. And then they want to come and snatch them. And because, firstly, my court did not give them security of tenure, because appointment would be for a certain period of time only. Whereas if you go to the High Court, it would be permanent, or some of them would be High Court judges that I wanted to keep in the Labour Appeal Court, but the President of the Supreme Court of Appeal or the Constitutional Court President or the other people would nominate them for higher courts. But I would have, sometimes I would have been the first one to identify talent and potential. Sometimes there may have been others who had also identified the people. But I would give them a chance, and in no time, other courts would see them and take them, and what could I say? I could not do anything. It was good for them. So that was the challenge. So obviously, that challenge doesn't apply in the Constitutional Court. But to the extent that there are courts where those challenges still exist, your question is a valid question, because they do exist. The Labour Appeal Court still has that problem. The Judge President of the Labour Appeal Court shared with me there are challenges because they are served by High Court judges. But if those judges get nominated for the SCA or the Concord, they are gone, you know. The Land Claims Court has those challenges. I think the Competition Appeal Court has those challenges. So I'm aware of all of these challenges that need to be confronted and dealt with. And I know them quite well because for a certain number of years as Judge President of the Labour Court and Labour Appeal Court, I was the victim of those challenges. So they need to be dealt with. But insofar as women are concerned, I believe that I would do anything I could to try and ensure that women who are outside the judiciary, lawyers, are made to want to come to the judiciary, and those who are inside the judiciary, they are given all the support that they can be given in order to rise. We have advertised under SAJE, that is the South African Judicial Education Council. We have advertised for women lawyers who may wish to be trained as aspirant judges. That program is going to be starting quite soon. The advert went out, I think, in December. And it takes the form of a project that Minister Bridget Mabandla ran with the judiciary when she was Minister of Justice, which was a very successful program. So we have gone back to it, and there will be a certain number of women lawyers who will spend a certain number of months being trained intensively to prepare them for later when they may wish to be considered for the position of judges. So I think that I would want to give as much support to women in that regard as possible. It would not be something that I'm starting now. I have been doing my best to give support to women over a long period. Thank you.
I think besides the issue of the women, I would really want to know how magistrates, or at that level, how also they could be empowered so that we can say, like we are saying, it's not too bad in the Constitutional Court, in the Supreme Court of Appeal, but at that level, where it is really the experience of ordinary men and women, and they are not really getting that service. How do you plan to build that cadre at that level?
Well, the program that I'm talking about is not exclusive to women who want to be judges. It also includes the magistracy. So if I could clarify that. But to the extent that, Commissioner, your question relates to the service that is rendered at magistrates court level to the people, how we improve it. That is part of what I was talking about when I said I am aware of various challenges that affect service delivery in the lower courts, because I've got the information, and what I would want is to meet all the relevant stakeholders to say, how do we improve this? Because our people are entitled to proper service, they are entitled to a better service, and what are the challenges? Why are they not getting it? As I said, I know most of the challenges already, but what would be next is to say, what do we do? Get everybody involved so that we make sure that going forward, those problems are solved once and for all and there is no recurrence.
So you will agree with what the Minister said earlier, that possibly we have that once off, bringing together everyone under one roof, understand what we need to do and develop a program of action?
Well, there is nothing wrong with the principle or in terms of what the minister was saying, if that's what he said. But I spoke earlier on about the PEECs, which are already in place. So those PEECs involve both the High Court and the Magistrates Court, District Courts and the Regional Courts. So, and their aim is to improve efficiency in the court so that the service that we give to the people is a better service. So the points that you raise go to exactly what PEECs are supposed to ensure. So one has got to say, if district courts A, B, C, D in the Western Cape seem not to be giving proper service to our people, we need to say, PEEC, do you know about this? What are you doing about it? Why is it continuing? What have you done about it? First of all, they must be aware of the problems. Once they are aware, they must decide what needs to be done to resolve those problems. But if they are not aware, then it's a serious problem, because at least you must be aware and you must know exactly what should be done to resolve the problem. And maybe if the resources are not there, that's fine, but you must know that the problem exists and what you think should be done to resolve it. You just don't have the resources to implement your plan.
If I may, Acting President, I'm still on the issue of efficiency and effective service. There is also the issue of turnaround times. That was something that have been apparently a complaint about, particularly in the Constitutional Court also, besides the lower levels. So if possibly you can also address on that one, and let me add the last one that I also wanted just to comment, but also possibly you can respond to that. I see in your institutional model, you speak about the Office of the Chief Justice to be a national department or function as a national department. Currently, it is a vote within the budget, because when there is reports, there is also a vote for the Office of the Chief Justice. Now, my point that I want to make is that I think you need to be very clear as to what you want the national or this Office of the Chief Justice to be. Because if you say same as the Auditor General, it becomes something else in terms of the Constitution. Because a national department, financially and overall, the PFMA, is it the PFMA, Kenny, that is informing, and then there is also the Civil Services Acts and things that is that is informing issues like HR and so on and so on. So I think before you will be able to implement this, you must be very clear as to how you want the outlook of this office or this department to be. I'm just mentioning it because I get a little bit confused, because in terms of the Constitution, we know where the AG's office are situated, but the OCG, you speak about the department, so I don't think that one need possibly response. But
I'm sorry, may I respond, because I think with respect, Commissioner, you may have either misunderstood me or misunderstood what you read. I said when I spoke this morning, I said there was a research that was conducted in 2010 and 2011 at the instance of the then Chief Justice Mlambo to look at what model we need. And that research produced a report. And in terms of that report, certain proposals were made. The proposal was in 3 phases. The first one was that there should be a national department. There should be an Office of the Chief Justice, which was established as a national department. That was done. Phase 2 was going to establish the Office of the Chief Justice as an entity similar to the Auditor General. Phase 3 was going to be the establishment of an office of the Chief Justice that would be a judicial council. And I said, the position is that I think in 2012 or 2013, proposals were made to the executive by the judiciary to say, this is what we propose. And as I said, President Zuma agreed to make the Office of the Chief Justice a national department, which was a very important step. But we need to move until we reach phase 3. So that's what the minister was talking about, because he also confirmed that they've never come back to us as the executive to say we agree or we don't agree. But based on what he said, there is going to be engagement, I hope soon, between the executive and the judiciary on the matter.
I will leave it there because I still have more to say, but we can still discuss it. It's not an issue. You are still the acting CJ. But what about the issue of turnaround times? And also, how do you, besides the fact that you spoke about the consultation and so on, but what do you think would be a better cooperation model that will really take you somewhere? That is my questions. Thank you.
Is that in relation to the Office of the Chief Justice or something else?
And in relation to the inclusivity over the spectrum. The issue of turnaround times.
Oh, turnaround time. Let me deal with that.
Okay.
Yeah, let me deal with that. I did say this morning, Commissioner Lucas and all commissioners, that we acknowledge that in the Constitutional Court there have been delays. We acknowledge that it's been legitimate for people to criticize us in regard to that. I said that we are doing something about it. I hope that we are going to sort matters out. In relation to turnaround time, I spoke about new application memos as well as reserved judgments. I said in regard to new application memos, we have started a new way of dealing with them, which we had not used before. There are signs that it is working and it's going to work and change the situation, and therefore change the turnaround time in relation to new application memos. And I said in relation to reserved judgments, I already have put a certain suggestion to colleagues. We have not finalized, we have not discussed, but we are still going to discuss that particular idea. But I did say that it may include that in some matters we don't all sit together, all 11 of us, so that some colleagues who may be behind with their judgments can get more time to write judgments. But I did say that if maybe that did not work, ultimately we may have to consider asking that a constitutional amendment be made that would enable a situation where less than 11 judges can deal with certain matters, maybe 3 judges, because at the moment we all have to take part in a matter that has come before us. Thank you.
Thank you. I think I will for now take the issue of how you are going to coordinate as your PEECs and your NEECs. Thank you very much. Thank you, Acting President.
Thank you.
Thank you, Commissioner Lucas. Commissioner Breitenbach.
Thank you very much.
Commissioner Breitenbach, please give, yes I can, but could you please give me a moment There's a member who wants to put a follow-up question to the acting Chief Justice. Thank you. Commissioner Mapisa Magula.
Thank you very much, Acting President. ACJ.
Madam Speaker.
Commissioner.
Commissioner, okay.
Thank you very much. Thank you very much, ACJ. There's a matter which she raised. Now she ended up with PCCs and NCCs. There's something you raised earlier on, which is that, in fact, prior to your interview, we interviewed some of your colleagues, and one of the issues they lamented, I think two of them lamented the fact that there hasn't been a forum where judges come together and interact and just engage for purposes of also restoring confidence in the ability of the judiciary in the country. Now, they said the last meeting they had was in 2009. And they were not raising it out of malice. I think they were raising it because they are concerns. Now, earlier on when you presented, you then said it would be seen whether, in fact, every 5 periods it's necessary for you to come together, because the meeting must be determined, or the conference must be determined on the basis of its merits, whether there is any reason, in other words, for you to come together. How do you reconcile that, what you presented to us, that which is part of your vision, and that which has been presented by 2 other judges, I think 3 of them, who are saying, really lamenting that there hasn't been this congregation of the judiciary?
Thank you, Commissioner. I made sure I don't say Madam Speaker now. Thank you. Thank you. Well, nothing I've said today in regard to conference should be viewed as me being opposed to a conference. I am not opposed to any conference. Actually, it may be that it would be a good thing to have it now. But what I did say is to share with the commissioners my recollection of what happened when there was a view that we should have a conference. But having said that, Commissioner, let me make this point, that I don't know which 2 of the 3 candidates you have interviewed may have made those points. I don't know, because I wasn't watching the interviews. I was busy preparing for my interview most of the time. But 2 of them are members of the heads of court, and they have been members of heads of court for a long time. And depending on when it was, when that issue was discussed, certainly one of them, I think, would have been part of the heads of court. So any head of court who has a view as to what judges should do or should not do is free to raise that in meetings of heads of court that we have, and we can discuss. Of course, it may be that other colleagues don't see it that way. It may be that they see it that way, but in the heads of courts, the Chief Justice doesn't dictate and say nobody is going to say anything here, my word is final. There are discussions, we share views. So, but speaking for myself now, in the light of the fact that we haven't had such a conference for a long time, I would be inclined to think there is a need. But again, last time, as I mentioned, there was the issue also of budgets. I think it had been said there would be budgetary constraints. I can't remember how many millions the quotation was. So I certainly am not opposed to judges having a conference. I think it may well be a good thing because we haven't had judges' conference in a long time. But obviously, we would have to look at budget, see whether there is enough budget, and if there are challenges there, discuss what is possible and what's not possible.
Very much. What happens in the event whereby judges offer to pay for themselves? Because apparently this is another option which had been raised earlier on.
Well, my recollection is that there may have been some judges who may have offered, but certainly I don't think that it was all the judges or the majority of judges who would have to be at conference. I may be wrong, but my recollection was that there may have been some judges who were prepared to pay for themselves, but not enough. But I don't have a clear recollection, but I do seem to think there was something like that. But if judges who are supposed to have a meeting and there are budgetary constraints, they are prepared to pay for themselves, there is no reason why a conference can't be held then.
Thank you very much, Acting President. I don't want a dialogue, but I think I do want to emphasize that this matter has been raised, and I think all of us appreciated the importance of holding such conferences on a regular basis, whether on a virtual, in a hybrid form or not. But the point is there were reasons why they were raising the issue. They identified some gaps, and I think that is one of those things you should also internalize.
Yeah.
Thank you.
No, there's no doubt, Commissioner, that whether after this process I'm Chief Justice or not, because if I'm not Chief Justice, I guess I'll still be Deputy Chief Justice. There is no doubt that I would want to raise it, whether I raise it as Chief Justice or Deputy. I would like that the leadership looks at it and there be consultation and we take it from there.
Thank you, Commissioner Mapisa Ngakula. Commissioner Breitenbach.
Thank you, Chairperson. Good afternoon, Deputy Chief Justice. How are you?
Good afternoon, Commissioner. I'm all right. How are you?
I'm well, thank you, sir.
Thank you.
My first question is about the effectiveness at the moment, or the efficiency at the moment of the courts. If you're appointed, you will effectively be the head of all the courts.
That's true.
Courts, lower courts, superior courts,
Yes.
whatever. None of them are functioning optimally. As a result of inter alia state capture in general and your commission more particularly, we should be expecting a deluge of high-level criminal matters to be hitting the courts sometime soon, one hopes. Do you have any plan about how to optimize the efficiency of the courts so that they will be able to deal with this deluge of cases? Because 2 or 3 hours a day is not going to suffice.
There is something that I missed, Commissioner, namely, I'm not sure whether you were referring to specific courts or just courts in general.
Courts in general. The courts that will hear these matters are possibly the regional court, the high court, and certainly there will be many appeals. So,
Yes.
How will the courts manage this massive influx of cases?
Well, of course, Commissioner, at this stage, I think a lot of people are talking about saying, well, it looks like it's going to take long before we see prosecutions. So there might be some time because there would need to be quite an army of prosecutors to deal with the cases. But my view is that when the NPA in different parts of the country, when they have cases that seem to require special arrangements, then they would need to talk to the judiciary. And the judiciary would need to make a plan to try and make sure that those cases can be heard as soon as possible. Obviously, the judiciary doesn't have resources because if you want many cases to be heard and you have a certain complement of judges in the particular court who have other cases other than the new cases emanating from the state capture reports, then you may need to bring in acting judges, get private practitioners to be brought in. You might have to bring in a lot of them in order to deal with the many cases that would emanate from the State Capture Commission reports. But if the executive says, well, there is no money, then there is not much that the judiciary can do. But we certainly, as the judiciary, would want to come to the party to make sure that the courts can hear as many of those cases as possible. All I'm simply saying is that it depends what is available to us in order for us to be able to do that.
Thank you, Deputy Chief Justice. And my final question is, you did mention in your first interim report that you held the view that the National Prosecuting Authority was perhaps not sufficiently resourced to deal with all these matters, and that perhaps some thought should be given to a different structure. What type of structure did you have in mind?
Well, I think that was within the context of the volume of the report that related to procurement, public procurement. And what I had in mind there was an arrangement in terms of which the anti-corruption agency that I recommended could have a unit that would deal with certain cases and prepare them and get them ready and then hand them over to the NPA when they were ready, simply because if they were just given to the NPA without another unit having worked on them and got them ready, there might not be capacity to deal with them. So what I had in mind was exactly that. Obviously, in our country, only the NPA has the power to prosecute and nobody else has the power to prosecute, because if you prosecute privately, you've got to get a nolle prosequi certificate first. So that's what I had in mind.
Thank you very much, Deputy Chief Justice. Thank you, Mr. Chair.
Thank you, Commissioner Breitenbach. Commissioner Mpofu.
I think he has been
No, good afternoon, Mr. Chair.
Good afternoon, Commissioner. Commissioner Mpofu.
Yes. Yes, no, I just thought, let me start with the declaration. Contrary to what is bandied about, you and I go a long way together.
Of course, of course.
But there are some
people who want to create mischief between you and I. I think we must forgive them. And maybe that should go into the issue of where you and I had an encounter, and I'll talk about first encountered each other, maybe I should say. You appointed me as an acting judge in 1999 or 2000 when you were JP of the Labour Court.
Hey, that's a long time ago.
It's a very long time ago. And this leads to something that two of the topics that I'm going to talk to you about. One to do with acting charges, the other one to do with transformation. So the way I ask these questions, there's one standard question that I ask all the candidates. Then I have to ask a transformation question because I'm here for transformation. Then I'll ask one that's tailored for you. And then you must hope that I run out of time because the fourth one is the controversial one.
So I must give long answers.
Yeah. And wink to the chair. The chair might make a ruling without a hearing. Okay. Now, the standard question is this. I've developed what I'll call a broad template about the requirements of the job. It's not an academic job. And you might have heard me putting this to the other candidates.
I must say I didn't hear because I didn't watch.
Okay.
I was preparing.
Are you superstitious? Right. Now, okay, this is how I go about it. I said that the job that you're applying for now requires broadly might require a whole lot of things, but three broad areas. Judicial skills and expertise, obviously, and that goes for issues like industry, independence, integrity, intellectual leadership, and you might add temperament. And then the second category is what I call leadership and people skills, the softer skills, yeah. Accessibility, judgment, not judgment as in writing a judgment, just patience, fairness, which is very underrated and abused, and emotional intelligence. Then I talk about administrative and management skills, which you know. So because it's late in the hour, I will not question you about judicial skills and experience because I think you are excellent in that area.
Thank you.
Thanks. Administrative and management skills also, I think having been a JP for such a long time, I've encountered you as one of your judges. You've been a DCJ, so I think we can take that for granted. So I'll question you more about what I call, where I sense that there might be some weaknesses in this other area of leadership and people skills. Maybe not people skills, because I think you've got the necessary people skills. And that goes to these issues of, whether you should have a press conference or not, those kinds of things that are gray area type of things. And I want to associate myself with what has been said here about some of the, at least perceived mistakes in those areas. But I want to ask you a specific question. Why, when you responded to Minister Sisulu, which part of what she said did you find so insulting?
Well, at the conference, I read specific portions. I don't have the article in front of me.
Maybe off the top of your head?
I remember, I think was the something like,
House nigger.
yes, that. There was also, I don't know whether licking, not saliva, I can't remember what the word is.
Yes, I remember.
Yes, and basically also what seemed to be that the suggestion that we black judges, black judges, were not thinking, we're just following
Masters.
masters. Yes.
Okay. Yeah. No, that's fine. Well, in the area of leadership, well, I can just give you some free advice.
Yeah.
When you're a leader, one of your jobs is to be insulted by all sorts of people who have never even met you. Yeah. Former President Khalima Motlanthe put it in more colorful language, which I cannot repeat here, of what a leader actually is. Yeah. So my point is that, yeah, something like that really, you don't have to call a press conference every time you get insulted. We get insulted, like this week we all got insulted for free by cantankerous former apartheid judges, and we don't respond to them.
Well, I certainly would agree that one doesn't and shouldn't, respond each time there is an insult. I certainly would not be planning to call a press conference or even issue a media statement each time the judiciary is insulted. So if somebody intended to insult us again, thinking would then come out again, we might find that we don't do that.
No, that's good.
But I particularly felt, and my colleagues in the leadership of the judiciary also felt particularly strongly in regard to this one. I think that you can accept that. I certainly accept, and I think the leadership of the judiciary accepts that there will be many instances where we will be criticized, maybe very severely, and maybe we'll even be insulted, and we'll just let go.
Yeah. Okay.
That's the position. Yeah.
I'm happy with that, and hopefully you also accept our criticism of you.
Yes.
For having reacted that way.
No, I accept completely that other people might see it differently. I have absolutely no problem with people taking the view that maybe I should not.
Yes.
I just happen to have a different view together with my colleagues.
Yes.
But that's fine, yeah.
Thank you. Now, on a lighter note, sometime in December, you and I were talking on the phone, and I managed to dissuade you from issuing a certain statement.
Yeah.
So you should have just come to me.
You see, maybe you are going to charge me a huge fee.
Yes. Okay. Now, the issue here, DCJ, is this, that we need a rounded product. The Chief Justice, as you know, you are a Deputy Chief Justice, must be rounded. And I think that maybe I can sneak this in, that this commission has been wrongly criticized. The way my reading of how we've done these interviews is to try and do exactly that, to zoom in on an area where we feel that is an area of weakness. There's no point in just dealing with your strengths. So Justice Madlanga was grilled on the 3.5 years left. Justice Meyer was grilled on the transformation and acting of white people who act in the SCA, because that was a particular criticism. And JP Mlambo, I think, on the issue of capacity to write judgments and so on, because we know about his other skills. Now, in your case, this issue about 3.5 years in the case of Justice Madlanga is even worse. Yours is 2.5 years. Why should that not be seen as a disadvantage in your particular case? When we do our deliberations, why should we not just say, it's just 2.5 years, let's just scratch him off? So it's an opportunity for you to convince us that that factor should not be overemphasized.
Thank you, Commissioner Mpofu, for that question. You know, whoever gets appointed as Chief Justice is not going to be starting afresh. A project maybe that will need 5 years, 10 years. There may be new things that he or she will come with, that I accept. But there is a system that is in place, that has been put in place, that enjoys the support of the heads of court. And that is very important, because when you are Chief Justice, you don't just do things on your own. Therefore, whoever comes in, I doubt that they are going to say the things that have been put in place with the blessing of the heads of court, which the heads of court say are working. Maybe they just need to be fixed here and there. I doubt that that person is going to say, no, let's start something new completely. I would think that they probably would try and work with what is there. Of course, there may be new ideas. Those new ideas some of those might fit in within 2 years or 1 year or 3 years or 5 years. Anything is possible. So my approach is that unless we had a situation where this commission knew that what needs to be done will take 5 years or 7 years or 10 years. If it was that situation where you said, what needs to be done will take 7 years, will take 10 years, then maybe it would be a different situation. But we have a situation where, in all probability, things that need to be done will include continuing with what is already there, maybe adding some things, but some of those things might not need to be 10 years or 7 years. They might be a few years. And of course, even with the former Chief Justice who left after serving for 10 years, it's not as if when they left, there could not be things that could still be done. But they leave them on the basis that whoever comes in can then either continue or change. So I think that there are quite some things that can be done. And as I said earlier on, when, of course, if I'm appointed as Chief Justice, there would be a position for deputy, and the president would decide how he decides to nominate. But I do have certain things where I think within that period of 2.5 years, I could make a big difference, particularly that would impact on the judiciary and as well as on people on the ground who use the services of the courts.
Okay, thank you. I hope the chair won't use those long answers against me. Yeah. No, I get your point, but I think the crisp question is this. All those things that you're saying, why can't you do them as Deputy Chief Justice? Why do you have to be the Chief Justice?
Well, of course, if you are Deputy Chief Justice, you don't have specific assignments or functions other than those that you are given by the Chief Justice, except insofar as there may be legislation that is specific. You know. So obviously, even if somebody else is appointed as Chief Justice and I'm Deputy Chief Justice, I can do those things.
Okay.
It's not as if it's somebody else who is Chief Justice, suddenly
You
I
stop.
won't want to cooperate. No,
I'm happy.
I'm not like that.
No, I know. No,
Yeah.
I just wanted it to be out there that
Yeah.
you will, if you are not appointed, you will support whoever the Chief Justice is.
I can assure this commission that I have high respect, high regard for each one of my colleagues who are candidates here. And we all get on quite well.
Thank you.
And if any one of them is appointed, we will work together.
Thank you very much, TCJ. Now, the transformation question is this. And for me, it's a source of disappointment because, as I said, 21 years ago, when you invited some of us to come and act there, you really sought out talent that you, at least that you perceive to be talent. And I remember there were people.
It was talent.
Thank you. Present company excluded. No, you had people like Nomali Chabalala, you know, were our peers, you
Yes.
know, aspiring labor lawyers, and you gave us that break. But I don't know what happened to that JP who could do that 21 years ago to a person now who can have a compliment, and this is my constituency is traumatized by this, a compliment of a lawyers serving in the commission where the statistics are like this, where there are 7 white SCs, 6 of them white males. I know that there are 3 African male SCs, the Seleka, Soni, and Noche. But 9 males and 1 woman, those are, what has happened to you?
To that vibrant young
yes,
JP.
who was looking out there and managed to find us from under the stones to now just, you know.
Well, thank you, Commissioner Mpofu, for that question. I think tell your constituency that there is something they misunderstand with regard to those statistics. They probably have forgotten how the Commission's legal team looked like when the Commission started. I can't remember the number, but whatever the number is, there were only 2 whites. The rest were black. And we had a media conference. I presented them to the media. There were, I think there were 3 women.
Yes.
Advocate Kate Hofmeyer, Advocate Leah Kabashe.
And Tandinomen.
Sorry?
And Tandinomen.
I don't know whether Tandinomen. No, actually, I think there were more because I think I remember another phase.
Yes.
So that first team was good, and it continued to be like that. But what happened is that at a certain stage, some of the lawyers had one reason or another to leave the commission. Sometimes it was that their practices were suffering and they needed to go back. Sometimes it was family reasons because the commission work was quite demanding. Sometimes it was that members of those lawyers had made an arrangement with me to say, I will give you my time up to when I complete this assignment. When I complete this assignment, please, I would like to go back to my practice and not continue into another one. Whereas there were others who were quite happy to start another assignment when they've completed another one.
Yes.
But when you look at all the members of the legal team from the commencement of the commission up to the end, the overwhelming majority of members of the legal team were black, and there were a number of women.
Yes. No, I understand that, but I want accept that answer at face value, DCJ.
Yes.
For two reasons. One is I can understand the attrition that you're talking about.
Yeah.
But surely you would still have had a duty in replacing them, to have a preference so that we don't end up with this picture, which I call traumatic. That's number one. Secondly, my understanding is that some of them left because they were disgruntled, probably because the leadership of the team was placed in one of these white SCs.
Well, let me say this, going back to your immediate past question. This is what happened. The people who left did not leave at the same time.
Yes.
So, like I would have at a certain time a certain number of whites and a certain number of women and a certain number of blacks, but some would leave and the numbers would still be fine, and maybe the whites would continue, more blacks would leave, because remember, a lot of black lawyers had started much earlier and their practices had been out of their practice for
is
some
your
time.
short answer that you had no option? There were no black silks available to replace these 7 white silks?
No, it's not the answer. The answer is simply that at a certain time when the white silks were taken, my recollection is there was nothing to be scared about the numbers. But what would happen is that later on others left. And most of the time it would be black lawyers because they had spent a lot of time already. A lot of whites joined later, yeah.
All right, okay, I'm still not
Commissioner,
here. Yes,
Mbofu,
I'm going to my
be
last
mindful
one.
of
Yes,
the
yeah,
time.
that's why for the record, I'm still not happy with that answer. But you and I can discuss it offline.
We can.
Yeah, so, thank you for your patience, Acting Chair. Now, the last issue that I want to talk about, which is, okay, I'll see how much I can test the patience of the chair, because it's not really the last issue, but I'll try to make it the last issue. It's a quick one. Going back to the question of acting, I was saying that when you asked me to act, I can still remember what happened. I got a phone call from you, and then I got another one, a letter from...
And you acted very well.
Thank you very much. You even recommended one of my judgments. It was reported.
Yes.
But, and then I got a letter from Minister Maduna and so on. Now, yesterday, I asked one of the candidates about how it came about that you invited him to act a month or 2 ago, and the answer was quite difficult to comprehend. So I just want to ask you, can you tell us the circumstances under which you invited Judge President Mlambo to act in the Constitutional Court now, and whether it had anything to do with this process? He said something about the president did this and then he didn't finish the sentence. What actually happened?
This is what happened some time back. I don't know whether it was 2020. I suspect it may have been 2020. The Chief Justice and I had discussed possible candidates for acting, and we had agreed that we should invite him, that is Judge President Mlambo, and the Chief Justice had asked me to make the phone call and talk to him and try and hear whether he would agree. And I made the call, but he, as far as I can recall, he declined. My understanding was that he was not declining on the basis that I'm not available at the stage, maybe I can be available later. I may have misunderstood him, but my impression was that he had declined. So I reported back to the Chief Justice. So we looked for other people. Then last year, after I went back to court and became acting Chief Justice.
Sorry, Mr. James,
Yeah.
I'm really sorry to interrupt. I do understand, he looked uninterested and then you called him again.
Yeah.
I just want this part.
This part, yeah, that's the
this
one I'm coming to.
Yeah.
I got a letter from the minister expressing concern that in the constitutional court, it looked like we were not affording judges, president, opportunities to act in the Concord. I don't know whether he included senior judges in general, but I know that he mentioned judges, presidents.
Specifically, yeah.
And he asked me if, I can't remember how he put it, but he was asking me that he should be allowed to act in a certain term. I think it was the third term, if I'm not mistaken.
Who's he?
The minister was asking if Judge President Mlambo I could consider him to act in the third term. Because he was of the view that he is experienced, he has contributed to jurisprudence. At that stage, I said no, because I had already enough people, or maybe not enough, but I finalized acting appointments. But I did say to him, we had asked Judge President Mlambo some time before, and he had declined. So it's not as if he had been sidelined. And I also explained, gave him names of a number of judges, president, who had been given opportunities in the constitutional court to say, here is our track record, how we have given judges, president, and other senior judges opportunities. But I said to him, if I recall correctly, because we had identified him before as one of those who are deserving of being given an opportunity, I could consider him at some stage in the future.
Yes.
Which
Okay.
is
No, thanks, that's enough. Acting President, I know I'm not allowed to follow up on my own question, but just a small question. In the same vein, can you just, and after this I'll go, can you just tell us now the circumstances under which Judge Unterhalter's acting came about? Because the reason I'm asking this is because there is concern that has been expressed that there are judges who were shortlisted, if you remember, and then 2 were selected by the president, and that at least one of those judges had never acted, but he was overlooked, and someone whom the commission had not even shortlisted has been made to act. Can you just clear the air?
Yes.
Who called who this time?
Well, this time it was this body in October when we finished our interviews that expressed the view that I should consider giving the candidates who had not been appointed or whom we had not recommended an opportunity to act. And I gave him an opportunity because that was the view that was expressed by this body.
No, but we said those people who have not had an opportunity to act. I'm just saying in that group, that included somebody who had actually, by this body's ranking, had been recommended. So shouldn't that person have been the first person to be considered rather than one who had been, let's say, not appointed? Maybe it didn't cross your mind, but I'm just saying.
No, my recollection is that...
And I'm so sorry, the reason I'm asking this is because that person did not put themselves forward again, and I suspect that they might have felt that, well, if I can be overlooked like this, then
I think that person, if I'm not mistaken, is somebody whose name we put forward to the president. So at the time I made the decision who to invite, we didn't know whether he would be successful with the president or not.
Thanks. Yeah, no, that
Yeah.
explains it.
Yeah.
Thank you very much.
Follow up,
I'm sorry, Acting
Chair.
President.
Yeah, follow up also, Acting President.
Thank you, Commissioner Mpofu. Commissioner Mlambo.
Thank you very much, Chair. Is it a norm for a minister to send people to heads of courts to act like it happened in this case where a minister suggests that JP Mlambo must come and act at the Constitutional Court?
Did you say, is it a norm?
Yeah.
Oh, no, it's not a norm.
It's a first of its own kind.
I don't know if he or any other minister may have done it before, but it's certainly not a norm.
It didn't come as a shock to you that a minister can go all out to suggest someone to come and act, particularly a person who's even nominated for the position of Chief Justice?
Well, I don't think at that time he was nominated. There were nominations, but I did see it as unusual, but I acted in the manner in which I did.
On a separate matter, Acting CJ, do you have a problem with criticism?
No, I don't.
Do you find a word, house nigger, an insult?
I considered it an insult.
It can be because in the historical academic category, this word is used by blacks criticizing other blacks. Malcolm X uses this word. Steve Biko uses this word when he describes 9 whites. Malcolm X says the house niggers actually wants to go and stay in a place like Saldanha and be the only one who says, I'm the only black here, because he loves his white so much. Biko says house niggers are black people who want to be white, who loves their white and want to destroy everyone who dares to destroy white supremacy. It can even be an academic criticism. And that's how she characterizes the black African judges who are sitting there, that they can go all out to destroy those who seek to destroy white supremacy with an intention to impress. It's an engagement which has not started now.
Well, I find, even when you explain it like that, Commissioner Malema, I would find it insulting to me.
No, but let me put it to you. Malcolm X says, the modern house Negro loves his master, prepared to pay 3 times for this house just to stay next to a white master. Biko says, house Negroes as a 9 white, blacks who seek to be white. Yes. Blacks who fight against disruption of white supremacy. That's what Biko says.
But if
Commissioner, I'm sorry, Acting Chief Justice.
Please.
Commissioner Malema, don't you think that it would be best, perhaps if there's a need to debate this at some other point, because here there's a difference of opinion. Whatever the case might be, as presently advised, if that is not an insult, that is clearly demeaning. And this is the position that is taken by the Acting Chief Justice. So, continuing with the debate has no virtue. It's not going to serve any purpose. You disagree on this, that's your understanding, is his understanding.
No, we're not disagreeing. You see, Chair, in this platform we have persuaded people who have arrived at certain conclusions, and they come to accept that, you see, with the information that you just shared, I now appreciate that the way I was viewing it is different. We always persuaded one another here, and we've had a lot of people saying, I concede, I buy into that argument. That's what I was trying to do. And I'm trying to say to Acting CJ, when a person says house nigger, and I'm not a house nigger, why should I be bothered? There are a lot of people who say men are trash. I'm not trash, but I'm not going to call any press conference and say we're not going to be insulted here as men that were trash.
Commissioner Malema, let me interrupt you once again. I will allow you to put your final proposition to him, and whatever answers he gives, that should be the end of the matter.
My proposition is that a black African female engaging black African dominantly males and calling them house Negroes is not an insult. It is a criticism that is always accepted, especially in the academia and amongst Africans who criticize one another. Do you accept that?
No, I don't accept that, Commissioner Malema. I think it's very insulting.
The last point, it means Malcolm X and Biko have insulted us. The last point I want to raise is the issue on 2.5 years left. To be honest, acting CJ, what is it that you are going to do which you can't do now, which you have not done now? So you see what Judge Maya did when she came here. She said, when I came in, these are the commitments I've made. This is what I was able to deliver on. As an acting, as a CJ, deputy CJ, I came in, these are the powers I can execute, and this is what I've done. All I hear is what you are going to do, not what you have done. And you have been acting as well. I don't hear you say, this is what I've done, going forward, this is what I will do. Because the truth of the matter, acting CJ, is that, and you described it very nicely earlier, you said you are sitting with a CJ in the same office, calling people to come and be chairpersons of a commission, which clearly told me that there's a collective leadership between the CJ and the deputy CJ. So why would you want to leave the position of deputy CJ and become a CJ to do which you can't do as a deputy CJ in the next 2.5 years?
Thank you, Commissioner Malema. Well, I don't know whether I should say unfortunately or fortunately, but I didn't serve for a long time as DCJ before I was asked to chair the commission. So for a long time, I've spent most of my time in the commission. So I have not had as much time as I would have had if I had not accepted appointment as chairperson of the commission to get involved in a lot of matters that I would otherwise have been involved in as DCJ. And of course, since I became acting CJ from July, everyone knows that I've been doing that while at the same time trying to finish the important work of the commission. Thank you.
Thank you very much, acting CJ. The last point, Chair, I'm going to ask that we be provided with the letter of the minister and the letter of the acting CJ to Judge President Mlambo to ascertain ourselves that indeed the minister did not attempt to interfere with this process after there were nomination of CJs. Because when we asked the JP Mlambo yesterday, he said, indeed it was in December, it was after. And Commissioner, I almost said Commissioner, Commissioner Nochesi said, in December, we had already defined the process, the roadmap to where we are now. So please, we want to get to the bottom of that matter.
Thank you, Commissioner Malema. I prefer to say nothing on that. Honorable Minister, you wanted to say something earlier.
Thank you, Acting President. I have requested my staff from the office that they must circulate the letter
Yes.
Acting Chief Justice that I wrote to you.
Yes.
And I want to confirm most of the things that you have said.
Yes. Thank
But
you.
I just want to go to section 175(1) of the Superior Courts Act. And I'm gonna read it for the benefit of the
Sorry, there's no such.
I beg you.
of the Constitution, I'm sorry.
There's no
I'm sorry.
such.
I was wondering.
Of the Constitution, I'm sorry, Acting
Yes.
Chief Justice. Section 175(1) of the Constitution says, the President may appoint a woman or a man to serve as an acting Deputy Chief Justice or Judge of the Constitutional Court if there is a vacancy in any of those offices, or if the person holding such an office is absent. It continues, the appointment must be made on the recommendation of the cabinet member responsible for the administration of justice, acting with the concurrence of the Chief Justice, and an appointment as an acting Deputy Chief Justice must be made from the ranks of the judges who had been appointed to the Constitutional Court in terms of section 174(4). What is your understanding of this section?
Well, it says the minister makes recommendations to the president with the concurrence of the Chief Justice.
Section 175(2) says, the cabinet member responsible for the administration of justice must appoint acting judges to other courts after consulting the senior judge of the court on which the acting judge will serve. And maybe what is your understanding of this one?
Well, you might have to read that one again because I'm not sure if it's relevant for this question.
No, I just want to show the difference.
Yeah, just read it again.
It's not formulated the same way as the first
just read it.
The cabinet member responsible for the administration of justice must appoint acting judges to other courts after consulting the senior judge of the court on which the acting judge will serve.
Well, I guess all you are doing, Minister, is just to highlight what the Constitution says.
Yes.
And argument might arise later as to what it means.
Yes.
Commissioner Malema asked me the question and I clarified whether he was asking whether it was the norm. Not whether it was lawful or not. And I said, no, it's not the norm.
Yeah, I'm still going there,
Yes,
acting
okay.
Chief Justice. The point I want to prick you in, as you said, when we had the conversation, you did not clearly remember what we were dealing with.
Yes.
To the best of my collection, what I remember is that you were now requesting a further extension of appointments of the two JPs. I think it was JP Tlaling and JP Japi, if I'm not mistaken.
Not Japi, maybe DJP Madondo?
Yeah, I think DJP Madondo. So I raised the matter to say, there are other JPs. Why don't we also rotate and give them the same opportunity that we have afforded these other JPs? And I think, if I remember, that was the discussion that I raised at the time, if I'm not mistaken.
No, my recollection is different. I received a letter from you. So it was a letter that I received first. That was, as I recall now, saying, in effect, it looks like you at the Concord might not be giving judges president opportunities to act. It may have said, and other senior judges, I can't remember.
Yeah.
But certainly judges president, opportunities to act, and that you thought that they should be given opportunities. And you mentioned Judge President Mlambo, and you said you think that he has the necessary experience and has contributed to jurisprudence or something like that. And then after I had got that letter, I first phoned you.
Yes.
And we had a discussion. And what I said earlier is what, in effect, I said to you. And I said, I'm going to write to you and basically say the same thing. And when I spoke to you over the phone about it, and I told you that we had previously invited Judge President Mlambo and he declined, you were understanding. That's my impression that, okay, then, that was my understanding. But I decided I was going to respond to your letter because it seemed you had a wrong impression about whether we had been giving judges president opportunities. And in my response, I gave a number of JPs that we had given opportunities before, as well as senior judges. I mentioned the chairperson, for example, even though he may not have been a judge, just to show that we had given senior judges opportunities. So that's my recollection of how it happened.
Yeah, maybe when the letters come, they will remind us. But my collection is that it was prickled by the fact that it is to give other JPs an opportunity. But the letters will help.
Yeah.
But I do agree that there was that deliberation. Will you say that is an anomaly as the minister if I raise an issue to say, but there are other JPs, what is the process and all that? Couldn't we consider them?
Well, I think you are linking it to Commissioner Malema's question. He was simply asking whether it's a norm, and I said it's not a norm, which is obviously different from whether it's lawful or not lawful.
No, is it lawful?
No, I don't want to get involved in that.
No, that's
what
fine.
I do know is that it's not normal. It had not happened in my experience, at least. But I think it had not happened to me, but we discussed it.
Oh, okay. Yeah. No, that's fine.
Okay, thank you, Minister.
It's fair to leave it at that.
Yes.
Acting Judge President, and I want to say, let the staff circulate the letter that
yes. And if they've got mine to you, they can circulate mine as well.
Thank you.
But if not, we will get it from my office. But if they've got mine that came to you, they can circulate that one as well.
Thank you. No, I can confirm that my collection also is the same with you, that it was before the processes started.
Yes, okay.
Thank you.
Thank you.
Acting Chief Justice, before we take a comfort break, I just want, following on this, would it perhaps have lessened or allayed your fears if the letter from the minister had merely said, consider inviting as many JPs as possible and not confine the invitation to, if I may put it that way, to a select few of judges president, instead of going further and saying, I've got this candidate?
Well, in terms of, and one can only answer that question in terms of what the norm is. If the suggestion was, it looks like you are not giving judges president an opportunities to come and act, just in general, maybe it might not have meant really anything. But the letter didn't just speak about Judge President Mlambo. I think it started by talking in general about judges president. And then Judge President Mlambo was then mentioned, but it started by, I think, expressing a concern that seemed to relate to judges president.
Thank you, Acting Chief Justice. I think it would be best perhaps not to draw you into what might turn out to be controversial. That should be a matter that, as members of this commission, should debate in the fullness of time.
Yeah.
Chair, can I come in there? Please, I don't want us to leave here with an impression that we are going to find in any of the letters a conversation that JP Mlambo must be appointed. That's not the letter I was asking. The letter we're asking to confirm if it came before the process or not. But this, the acting CJ says, following the letter, they had a conversation with the minister where the minister was very specific on an individual who must be invited to come and act. It's not in the letter. We won't find it in the letter.
No,
So we should take what the acting CJ says as is, because if we're going to debate there, and then the debate says, yeah, in the letter there is nowhere where they say Mlambo must act,
No, there is.
then we'll be conflicted. But all I was saying is that I needed the letter to confirm if the letter came before the processes, and then the letter to JP to come and act, if it came before the roadmap were outlined, because he said the letter came in December, and if it came in December, it was already afterward outlined the roadmap to where we are now.
Commissioner Malema, obviously, the letters will be read in conjunction with whatever responses came from the
Thank you, Chair.
acting Chief Justice. They
May I
will
just
not be seen
clarify?
in
May I just
isolation.
clarify one?
By all means, acting Chief Justice.
Yes, I just don't want Commissioner Malema or anybody to misunderstand. The conversation that I talked about, that I had with the minister, happened after I had received the minister's letter, but before I responded in writing to the minister. So before I responded to the minister in writing, I phoned him. We had that conversation. After we had spoken, I then wrote a letter which was saying, no, I can't take him, and we are giving opportunities to JPs and giving him a list. So I just want to make sure the sequence is not misunderstood.
Yes. Thank you, acting Chief Justice. Could we, I make it's 10 to 6 now, but I think it's time that we take a comfort break, say 10 minutes, and I still have about 2, 4, 6, 8, 9
I'm sure 5 of them have withdrawn.
members of the commission. Members of the commission who still have.
I am mostly covered. I have very little email.
Yes, we can only determine that when we resume.
Okay.
Thank you.
Hey,
Make
this
it
this
10
seat has been
minutes
very hot.
strictly.
I was hoping you are saying I'm done. It's been very hot, this seat.
So I propose that in the meantime, we continue with the interview. We'll deal them at the tail end of the interview.
Okay.
Thank you. Commissioner Dodovu, you are the next.
All right. Thank you very much, Acting President. Good evening once more, Justice Zondo.
Good evening, Commissioner.
Yes,
So it's been a long day. We started good morning, good afternoon,
Yes,
and now good
exactly.
evening.
Yes. I want to traverse with you your CV, which is book 1 of 1, and I want to take you to page 4 of that booklet.
Page 4.
Yes,
Is that the paginated 4?
yes, yes,
Okay.
paginated 4, not the
Okay.
marked. Yes.
Okay.
I'm very much proud of you in respect of the articles that you served, culminating in your conferment as the attorney. And I can see here that in 1985, in March, until August 1985, you served the articles in the eminent firm of Mkenge.
Yes.
I'm sure despite what happened to the couple in 1981 and 1985, you must feel very much proud that you were part of this, you were nurtured and elevated by them.
I feel very proud. I feel very privileged to have been articled to Mrs. Mklenge. Unfortunately, I never got to meet
Yes.
Mr. Mklenge.
Yes, I can see that.
Yes,
The point why I'm
yes.
raising this is because, as we all know the history of this country, Ms. Mklenge was brutally murdered cold-bloodedly on the 1st of August in 1985. And at the end of the year, at the end of the month, you resigned.
Yes, yes.
Was it because there was no principal who could chaperone and usher you
Yes,
through the process?
I think there was no one, her other partners didn't qualify to take an article clerk, if I recall correctly, or if that was not the case, maybe they had reached the maximum number they were allowed to take. But my recollection is that they didn't qualify. I think at that during that time you had to have been a partner for, I don't know whether to have practiced for 3 years before you took an article. I can't remember. But my recollection is that they did not qualify.
I would imagine this would have been a very painful moment because, as we understand, when she was cold-bloodedly murdered, it was only a week after she addressed the
Yes.
funeral of the Cadre Four.
Yes, yes, yes. No, it was a very...
Fort Kalata, Sporam Konto, and Sicelo Mhlauli.
Yes, no, it was a very painful, period. She had been very kind to me. She had allowed me to attend lectures while I was doing articles, and not many principals would allow you to do that. And when the news broke out of her assassination, I can still remember the spot on which I was on campus. And I remember it was a sunny day in the afternoon or evening. But it had been a sunny day that day.
Despite the setback, you resurrected, and here you are now,
Yes,
the acting CJ, aspiring to be at the top echelons of the judiciary in this country.
No, thank you very much. It's just a pity that she was assassinated because I think she would have been I would have very much liked to see how she contributed in my life. I have told the story in other fora, and I think some of the commissioners here may have been in some conference where I spoke to say, to articulate the role she played in giving me confidence when she allowed me to have a full office, have a secretary, even though I was an art clerk myself, and showing confidence in me and saying, we don't know labor law, but we think you have some experience from the Legal Resource Center. You must open this labor law department and run it. And
just as a final word on this subject before I get to the next one, their names are engraved in the head office of our prosecuting authority.
Yes.
How I wish that men and women who are in the NPA can, symbolize and emulate their exemplary leadership in terms of how to bring about justice in our land. Yes, I wish. Having said that, let me then go straight to the issues that you raised. I carefully listened to you when you shared your vision. And please allay my fears and correct me if I'm wrong. You put emphasis on the issues of the institutional model that you must be implemented. You also spoke of the infrastructure that is not the state-of-the-art infrastructure within the judiciary. And as you were talking, I was carefully listening to you. You kept on saying, I've been told by Judge President, I've been told this. What concerns me is the fact that it doesn't seem to me that you personally, as either the acting Chief Justice or the Deputy Chief Justice, you have gone there personally. You have seen it, you have witnessed what is happening. It's not only what you heard from them. If that is the case, why are you not doing that? Visiting, especially those in the remote areas of our country, as part of leadership.
Yes. No, thank you. That's a legitimate concern you were having. But let me give you context. These PEECs that I was talking about, they are provincial structures. They are chaired by the judges president in the different provinces. And they are attended by representatives of various stakeholders involved in the justice cluster. So the Chief Justice would not go and sit in those meetings. He would sit in the National Efficiency Enhancement Committee. And that is the committee to which the PEECs escalate matters which require national resolution or national leadership. So I have to rely on the judge's president with regard to how those PEECs are functioning.
But that's my point. Why don't you personally visit, go there to those courts and personally experience what is really happening when they say there are cracks?
Okay, no. Now I understand. So it's not so much about what the JPs say. Look, one, since I became an acting CJ in July, you will know that I've been also doing the commission work, which has been under pressure to be finished. So I wouldn't have had time to go and visit. But if I'm appointed as Chief Justice, there are a number of courts that I would like to visit. So certainly, when the commission work is done. But in the light of the fact that I have not had the opportunity to visit, it was legitimate to say, JP, you are the leader of the judiciary in that province. you chair the PEEC, what is the state of the courts, including lower courts, in your province? And then they can give me reports. And that, but I've also got reports from the lower judiciary, or people who could get information for me from the lower judiciary. But if I'm appointed as Chief Justice, I would visit some of the places myself.
Just the last point, again, as I was listening to you, sharing with us your vision, there are areas that are of concern to me that you didn't touch on. Firstly, my impression, and correct it if it is wrong, my impression is that you just want to continue from where the former Chief Justice was until the end, without new innovation, without new perspectives to the court, without new entrenching new things that will take the court to the higher level, to the higher levels.
Well,
I'm saying this, listen
yes.
to me, let me tell you why I'm saying this. I'm saying this because at the moment, as it is, there is a serious concern about the confidence of our courts, which in all intents and purposes, it has gone down. People no longer trust the courts in the way that they used to. There is a discussion around the single judiciary. I thought that you will share with us, if you support that, what is it that needs to happen in respect of the modernization of our courts, which is also a topical issue. For me, all of these issues are current issues that must be taken forward. And as an aspirant Chief Justice, I was carefully listening to hear what are your views about all of these topical issues that must be attended. Concomitant to that is the fact that there is an attack against the judiciary, that you delay your judgment, for example, that the quality of judgments are problematic, the languages that you use is combative, and all of that. And for me, sitting here as a Deputy Chief Justice, am I incorrect to expect that these are the articulations that must encapsulate your vision going forward?
No, thank you. I hope I'm going to be able to deal with all of the issues you raise. But let me start with regard to your impression that I was just going to continue from where the former Chief Justice left off without anything new that I would come with. What I was saying was the structures that have been put in place while I was also part of the leadership. These structures, like the PEEC and the NEEC, these structures enjoy the support of the collective leadership of the judiciary, the heads of courts. They support it. Their position is that these structures are working well. They might need to be fixed here and there. So my approach is that I don't want to unduly want to change something that can be fixed to make to work. But that doesn't necessarily mean that if we look at some of these structures in terms of how they work, we can't start saying, but what about if we do it this way in order to improve or enhance its performance? We can look at that, and ideas about what else can be done would also be explored. It's important to make sure that the heads of courts, come on board, because they are very critical in whatever the Chief Justice does. So certainly, it's not like there is an idea of closing one's mind to say one will not introduce anything. But the idea is, let's see where things are not working, and where they are not working, if we can fix them, fine. If we can't fix them, let's look at introducing other things. But appreciating the role of the heads of court in the whole process. I certainly support the concept of a single judiciary. It's just that you are given a certain amount of time within which to say what you say, and I think I went beyond that, and you accept that you may be asked on some of the issues that you would have liked to deal with. I certainly support the concept of a single judiciary. On the modernization, I did say that I embrace it, and the reason why I didn't go into details is because I know that you have been told about it by Judge President Mlambo, for example, but I wanted to make it clear that I embrace it. So, yeah.
Thank you very much, Acting President.
Thank you, Commissioner Dodovu. Advocate Madonza.
Thank you, Acting President, and good evening, Deputy
Good evening,
Chief Justice.
Commissioner Madonza.
I've been largely covered by a number of questions which have been put to this witness. I had 5. Now they've been reduced to 1.
He is a candidate, Commissioner Madonza. He is not a witness. Thank you.
I'm so sorry, Deputy Chief Justice. But let's call size 10 or I'm so sorry, yeah. There is a view, DCJ, that the SCA and the Constitutional Court as appellate courts should be collapsed into one apex court with panels to determine appeal cases in order to improve access to justice and remove a layer of appellate courts. I recall that the jurisprudence of your court, the Constitutional Court, has been that they benefit a lot from the wisdom that may come from courts below it in terms of fashioning or purifying the jurisprudence that emerges ultimately from an apex court. Is there any justification in that view? Do you embrace it? Or do you hold the traditional view that there should be an intermediate appeal court?
Well, at this stage, I would stay with the 2 courts as they are. This particular issue, this view about the SCA and the Concord coming into being one court is not new. It was debated for quite some time, many years ago when I was still JP, and ultimately it was not accepted. It was debated among heads of courts. It was debated in meetings with I think the Portfolio Committee of the Department of Justice and Constitutional Development, if I'm not mistaken, many years ago, as the ministers, different ministers who came. But it may well be that a time will come when maybe it will attract enough support as time goes on. So my own view at this stage would not be to put the 2 courts together. But if there are further arguments, one can listen and keep an open mind.
That is primarily because you value the wisdom that comes from the lower courts.
It's very important, particularly, also from the High Court. But if a matter has been dealt with by the High Court and dealt with by the SCA, there is a certain value that it's been dealt with at those two levels. And of course, if one is looking at the idea that the Constitutional Court should not have too many cases that it deals with, then it means a lot of matters should end at the SCA and not really come to the Constitutional Court. Those that come to the Constitutional Court must be matters which qualify because of certain level of significance and so on. But it may well be that at another time the view might attract enough positive responses.
Thank you. It seems to me, since you hold that view, it seems to me then there is merit in the concern raised out there in the public about the election that you made in the warrants case against Mr. Zuma.
In which case?
In the warrants case, the Mr. Jacob Zuma warrants case, the contempt case, so the contempt case.
Oh, okay, right, okay.
In not allowing the case to go through the High Court, the Supreme Court, and ultimately in the Constitutional Court. I don't want you to comment about the case itself, the judgment, because judgment is done and dusted now.
Yeah.
It seems to me there was an election open to you to take two routes. One, to report the matter to the prosecutorial authority to prosecute the contempt, or to go to court. But you chose the route that said it must go directly to the Constitutional Court. That court now being deprived the wisdom of the other courts if it ultimately had to determine the issue. But it is important for the other reason as well, and I want you to deal with it holistically. The other reason why it would be important for it to go through other courts is the level at which you were at the Constitutional Court at the time. As a deputy chief justice, in a matter in which your colleagues were to decide a matter brought to court by yourself, would that not have created a serious pressure on the other judges having to decide a matter, or possibly even dismissing the matter of their own boss?
Well, the previous judgment, because we are now talking about the contempt matter, the previous judgment of the Constitutional Court had already shown that my colleagues could criticize me, and which they did in the first judgment. They saw the matter in a certain way in terms of how I had handled the matter relating to President Zuma. So there is certainly, I would not have had that view even before the first matter, but certainly not after the first matter, where they had clearly shown that it didn't matter that I'm their colleague. I mean, I had been party to judgments before where we had dealt with cases involving our own colleagues. I was part of the panel that gave a judgment involving Justice Jafta and Justice Nkabinde. So in that court, it was not a first that colleagues are going to deal with a matter that puts on the spotlight their own colleague. Indeed, there was another matter, but I was not there when justices of the Constitutional Court dealt with the matter involving the extension of the term of office of Chief Justice Mlambo. He was the Chief Justice. They dealt with that matter, and they found basically against him. So there was a history. But even if there was no such history, I would never have thought that justices of the Constitutional Court might not do the right thing just because I am one of them.
Thank you. I thought I should clear that up because it was raised with another candidate earlier, yesterday.
Oh, okay.
And also in that context, to pick up from what Commissioner Nyechesi raised with you, I understand your position that there may be review applications emanating from the state capture report. And it seems to me from what is happening in the state capture and the flurry of complaints and objections against you, that the debate is more likely to be ad hominem attacks on you, as opposed to really reviews on rationality or legal grounds, which might not involve you personally having to depose to affidavits. Now, if you are appointed as the Chief Justice, in circumstances where there's a reasonable prospect that you may be called upon now and again to defend your integrity, which is impugned in proceedings challenging your decision in the State Capture Commission. Is it not unenviable for a Chief Justice to be deposing to affidavits each time that the sun rises from the east?
Well, I think that whether it's the Chief Justice or the Deputy Chief Justice or Judge President or any other judge, if somebody takes you to court because of the performance of your constitutional legal duties, you can't simply on that basis and say, you can't say we should not appoint so and so because of that. It's different if the manner in which that person has maybe conducted themselves is the one that gives rise to concerns. So it should not be that people who don't want me to be appointed as Chief Justice because they feel aggrieved by one or other thing I've done, one or other decision I've made in the Commission, and maybe they've vowed that he must never be Chief Justice, that because they are going to launch a lot of review applications, then they are going to succeed by saying, but there's going to be so much litigation against this one. So my approach is that the correct approach I would urge on this commission is to look at my candidacy and look at what I have done in the commission, and if I have not done anything that disqualifies me, the commission should make whatever recommendation or decision it considers fit, but it should not make me feel or any other judge feel that, hey, you're not accepting these commissions is career limiting. So if you are asked, don't agree, we should not have that situation. We should encourage judges that if you are asked, the country needs you to handle a commission, you must make yourself available.
Well, maybe the lesson is that it should not be the active judges.
I agree with the view that preferably, at least, it should be the retired judges. I agree that that view is preferable.
Thank you.
Thank you, Commissioner Matanzala. Commissioner Tsepe.
I waited. Hi. Thank you, Acting President. Good evening, Acting Chief Justice.
Good evening, Commissioner.
Thank you for being patient with us.
Well, thank you for giving me a hearing.
Acting Chief Justice, I have just a couple of questions. The one is almost a follow-up relating to the question of modernization that the minister raised with you, and I think Commissioner Dodovu also raised. And I've asked the other candidates, and I'm happy you embraced it, to use your language. But one of the key issues I have raised with the other candidates is, for us as practitioners, we found value in modernization and online case line, virtual hearings and all of that, and it has meant there is access to justice, but that is mainly particularly to those who have access to these resources, whereas for the vulnerable people in our country where such resources do not exist, in your mind or from your plans, what should the Chief Justice be doing to ensure that access to justice is not just materializing to a few, but it is broadened, particularly when it comes to modernization and online access to courts? That's my first question to you.
Yes, can I deal with it? Well, I think that everything possible should be done to make sure that people, for example, in rural areas are not disadvantaged when it comes to court modernization and IT. But in terms of exactly what it is that might need to be done to make sure they are not disadvantaged, certainly one would need the experts who can say, here is advice of what can be done. And if the Chief Justice is somebody who is embracing the idea, he's likely to go along. So the experts can advise as to what can be done.
Thank you, Acting Chief Justice. The reason I'm asking this and would have liked to hear if you have thought about it is the lockdowns during the COVID pandemic meant that this is the one area where easy access to justice was happening online. And it's not, for me, this is one of those priority areas where we are still in a state of disaster management, and therefore access to court is still a bit of an issue here and there. So online justice, in a way, is an issue. So it is in that context that I was asking.
No, thank you. That context is very helpful. In the commission, it didn't take us long after the termination of the hard lockdown in 2020 for us to start allowing witnesses to give evidence via Zoom. And initially we were concerned because it was the first time one had to do this, whether it would work, but we tried it a few times and it worked. Sometimes there were hitches here and there, but it worked, and we used a lot of that. There is no reason why people who are in rural areas or wherever can't participate in course through Zoom and or other methods if they can, and save on traveling and costs and so on. So all of that should be possible. Actually, I think that as far as possible, we should do away with unnecessary traveling for people to come to court. Anything that can be done to make sure that they can interact with the court from their offices or from their workplaces or from their homes is fine.
Thank you, Acting Chief Justice. The second question I wanted to discuss with you. You spoke about the quorum of the Constitutional Court when you spoke about your vision as the head of the Constitutional Court, obviously, were you to be appointed acting Chief Justice. There is the issue about the minimum quorum of 8, and you would know there has been some judgments where there were hang judgments in a way because of the quorum. And there has been proposals of amending, I think it's section 1672, if I'm not mistaken. You raised that only in relation to panels, more to deal with the other cases. Do you think the amendment should be to, or to resolve that matter, should we be amending it 167 to ensure that the quorum is not an even number or it's an odd number, or do you think that practical directives should be so that you have 9 judges sitting or 7 judges sitting as opposed to an even number where you have a 50-50 split of the court? And obviously that is undesirable because you don't have certainty on jurisprudence.
No, I don't think the issue of quorum requires an amendment of the Constitution. 2 points. When I referred to the fact that the quorum in terms of the Constitution is 8, I didn't necessarily mean that we would have to sit 8. We have had occasions when we have set 8, and I agree that it's undesirable because if there is no agreement, you could end up with a tie. So I think the preferred option, instead of having 8, is to have 9, because then you won't have a tie. But nevertheless, if you have 9, within the context of what I was talking about in the morning, it would still mean that you have 2 colleagues who could be asked not to participate, or they could volunteer not to participate in a particular matter so that they could go and write their judgments that have been outstanding for a certain period of time. So that's possible.
Thank you, Acting Chief Justice. I didn't mean that was your suggestion. It was a suggestion proposed by the other candidates previously.
Okay.
Yes, I understood I understood your suggestion completely. Acting Chief Justice, the last question I wanted to raise with you related to transformation, and you raised it as one of your the priorities you would deal with. In the previous interviews, we have heard that, for example, there is no national transformation program which sets out some of the goals we wanting to achieve in order to transform the judiciary time periods to deal with that. And on gender, we don't have an anti-sexual harassment policy nationally. Some divisions do have, but not all of them. There is no maternity leave policy, for example. In my mind, I know you said that from a race perspective, we've come a long way. But my concern is, how do we determine whether we've come a long way when we have not put in place targets? We're aiming for a target, both at gender, at race, and the other consideration. And I just wanted to know whether it's something you have considered, and if not, is it something that you think we should be working towards, so that we are working towards a particular goal, and that some of these policies that do not exist, because transformation is not only about the numbers, but once the people are in, that we have mechanisms to support them?
I guess that with regard to targets, we could have maybe fixed certain targets some time back, But I suspect that maybe our focus was we are still so far away from whatever target we might wish to fix. Let's push, and maybe when we have reached a certain point, we can then say, okay, maybe it's not too far. The target we would put is not too far. Then maybe we can talk about it. I'm just saying, but not that, as far as I know, there was a discussion, But I think there is an acceptance, a general acceptance that with regard to gender, for example, we should have more women in the judiciary than males, because there are more women in the population. There is that view. But that's what I can say. It may well be. I think it might be discussed whether or not we should have a target. But certainly, I think that we have not reached the point which we should reach with regard to gender transformation.
Acting President, I'm sorry to disturb you. Acting Chief Justice, I don't want us to get stuck in the target. I'm just talking about objectives. What do we want with transformation broadly? So I didn't want you to be stuck on target.
Yes.
It's more the broader objective of transformation.
Yes. No, of course, with regard to transformation, we want to make sure that we have a judiciary that is representative of us as South Africans in terms of race and gender, but also we need to make sure that women and black judges get to be involved substantially in all branches of law so that they can make their full contribution to jurisprudence and take part in all our courts up to the highest court.
Thank you.
And on maternity leave, we might not have a provision that talks about maternity leave applicable to the judiciary, but we do have a provision in the law that says that a judge may be provided with may be given special leave. I can't remember whether the special leave is supposed to be given by the minister or by the president, but may be given special leave for any reason that either the president or the minister, whoever it is, may deem sufficient, which I think maternity leave would fall under, as far as I'm concerned. And for some reason, I think I've had judges who have gone on maternity leave, even if it's not called maternity leave, if I'm not mistaken. Sexual harassment policy we might not have, but any judge who against whom there would be sexual harassment allegations would be held before the Judicial Conduct Committee if a complaint was laid.
Acting Chief Justice, thank you for the response, but I do think that in the journey on transformation, certainty on these sort of policies, I think particularly regarding gender transformation, I think they are key. They make everyone who's there understand where they stand, particularly on issues of sexual harassment. These are sensitive issues, and women judges, those who need it, need to know what processes are there, what support structures are there for them, if there are any. And I think it would be helpful, I think, for the judiciary if these would be put in place. That is my view, and I would like to know that were you to be appointed as a Chief Justice, this would be things that you would try and put in place. Sorry, I know I'm saying were you to be appointed. My view with the other candidates where they are already in leadership position and these things should be done, like as in yesterday.
Yeah. Thank you, Commissioner. I simply make the point that to the extent that there may have been a concern by any of the other candidates, particularly those who might be in leadership positions within the judiciary, to the extent that there might have been concerns that there is no policy, sexual harassment policy and maternity leave. I would simply say they must raise these things in the heads of courts forum. They are members of that forum. They are not restricted from raising them. And certainly I would be very keen to make sure that, I give my support.
Thank you.
Thank you.
Acting Chief Justice, the last issue relates to appointment of acting judges. The GCB, somewhere in one of the comments they've provided, is that sometimes the process doesn't seem to be completely transparent. And one of the questions I've raised is, shouldn't we have a policy on how we appoint acting judges, so that there are no misunderstanding or perceptions created about this? And I just wanted to find out from you what your view is on that. And
I think, if I'm not mistaken, there is a document that the heads of courts have agreed upon, which sets out factors that are taken into account. I don't know whether it may have been shared with the public or with the profession, but I think there is a document that does that, even though it might not be a document that has been there for a long time, but I think there is one. So maybe arrangements can be made for it to be shared with maybe the commissioners.
thank you so much, Acting Chief Justice. Thank you, Acting President.
Thank you.
Thank you, Commissioner Tsepe. Commissioner Barnard.
Thank you. Good evening, Acting President and Acting Chief Justice.
Good evening, Commissioner Barnard.
Just with reference to your insolvency, the two, I think, insolvency cases that you included in the bundle, or insolvency-related cases. The one was the Section 197, Section 38 of the Insolvency Act that was later amended, which was a long time ago, around about 2002. And then Dima and Waverley case and so on. Don't you think that there's some pretty old procedures in our courts? I've heard you speak about a possibility of actions being started by affidavit instead of in the process that we are used to. I'm thinking of your Insolvency Act, which has things like it's a 1936 Act. Yes, there have been sporadic amendments, but you have very old procedures that have been in place for applying for voluntary surrender, compulsory sequestration, and rehabilitation and the like. Even the administration orders in the Magistrates Court Act, which is referred to as insolvencies in the small, it's 1944 Act and processes that have been almost patched over time. So do you think there are some old processes in our courts and in our structures which need some rethinking in your head, if you would become head of the judiciary and so on?
I certainly think that it's proper that from time to time we need to look at systems that we have and procedures that we have and determine whether they still serve the purpose that they should be serving and whether they should be changed or repealed. So that would be my view, that we should from time to time do that so that we can amend them if there's a need, so that they serve present purposes better, because they may have been put in place in 1937 in a very different society, and lots of things have changed. So I didn't know particularly with regard to procedures in the Insolvency Act, but I certainly think that if the Act is as old as that, it's proper to have a look at its procedures.
Then as far as the definition, I'm thinking section 165 and 166 of the Constitution, so, and thinking of the definition of other courts in terms of Act, what would you say would be your vision for something like the small claims court?
I think the small claims court is an important court, and I would think that one would need to have a look at what it is doing. I must confess that I haven't had much to do with small claims courts in a very long time. So, but certainly I would be interested in seeing how they are functioning now and what can be done to improve them, because as far as I know, a lot of people get access to justice through those courts for claims that fall within their jurisdiction. So whatever it is that may be necessary to make them work better, I would be wanting to have a look at that.
Now you've provided some good chairing of the JSC interviews in October. You have you leave a legacy not only as a leader but as a developer of leader. If one thinks about that history in the Labour Court and the Labour Appeal Court, which turned out many leaders throughout the judiciary. So it's not that the leadership ability is in doubt, but the criticism that you referred to that the Constitutional Court had regarding the Commission, what they say is that the Commission it was the Commission's own conduct almost that caused the need for the direct access, and they even go as far, I think, the Constitutional Court in paragraph 67 of that judgment of the Secretariat versus Zuma, where they say that they refer to the Commission's maladroit conduct, which is really, the meaning is inefficient or inept or clumsy. But it seems that there might have been a lack of foresight. And so my question is this, is that something that, how can that be prevented in leadership of the judiciary, in the leadership role of the Chief Justice?
Just to make sure I understand, are you referring to the Constitutional Court's criticism of the Commission in that first case?
That's right, that's correct.
Oh.
So the wording,
well, yes, well, look, I respect the view that was taken by my colleagues in terms of how I handled that case. This was a very tricky case, and different people would have handled it differently. It was quite a tricky case. President Zuma, if he took part fully in the commission, his evidence would have been very, very important. So I wanted him to take part in the commission. I wanted to have his side of the story. I wanted him to explain things before the commission, before the nation. But for me, my consolation with regard to that criticism is this. When I was handling that matter, I was alive to the fact that I needed to be careful, because if I handled it in a certain way, Mr. Zuma could go to court, and if the court made a finding that we had been unfair, I had been unfair to him, it could taint the whole commission, and the damage that would be caused by that finding would be very far-reaching. I can live with the fact that the court criticized me for the way in which I handled him, but I'm happy about the fact that it never said I treated him unfairly. And I'm happy that it seems to me that certainly it did not think I had treated him unfairly. I think if I had handled the situation in such a way that he went to court and was successful in getting a finding that I had treated him unfairly, it would have been very, very bad for the work of the Commission. So I can live with the criticism, but I'm happy that the Commission was able to go as far as it went, and that there was no finding that I treated him unfairly. At least up to now, there isn't.
And then the last aspect I want to deal with is just you made mention to there was a time in the Commission's period where the funds were drying up so much to the effect that there was concern whether people would be able to be paid, etc. And they just really underlined the fact that for a true independent judiciary, one needs to have the budgetary things sorted out. Do you have any comments on that, and what would your position be, or how would we deal with this?
Well, it is true that generally speaking, you would want to sort out the budget before or even before the Commission starts. But what is also true is that originally the State Capture Commission was meant to take six months, and then it went on and on because the terms of reference had been widened, and so I can understand difficulties from the point of view of National Treasury and Department of Justice to adjust and make money available on an ongoing, and they think that in 3 months' time we are going to finish, and then suddenly there's another 3 months and then another 3 months. So I can understand there are challenges from that context.
Sorry if I can interrupt now. I'm actually moved on. I made an analogy with the Commission. So I'm saying, just like the funds that dried up caused problems for the Commission, if the funds aren't sufficient for judiciary, then that could be problems for judicial independence. And so the question is the budget for the judiciary.
Oh.
And so that's actually where I wanted to focus your answer.
Yes.
What are you looking forward to ensure that that's not a problem which eventually impacts on the independence of the judiciary?
Well, the model that I spoke about earlier on, I think would make sure that that problem doesn't arise. The model that I spoke about once it has gone up to phase 3, I think that problem would not arise.
Thank you very much. Thank you.
Thank you. Thank you. Thank you.
Thank you, Acting President. Good evening, Acting CJ.
Good evening, Commissioner.
How are you?
I'm all right. How are you? I'm tired, but I'm okay.
I can see that. ACJ, thank you so much for the good work that you are doing for the country, and I believe majority of South Africans appreciate what you are doing.
Thank you.
And also thank you for the training that is coming up, because I believe it's not only aspirant women judges who are going to benefit out of it, but also women practitioners will benefit, because the skill that they're going to get there, they will be able to apply it in their practices. ICJ, Commissioner Tsepe here spoke about these crucial two policies, which the harassment, sexual harassment, and the maintenance, and the maternity leave policy.
Yes.
I heard your response to that regard. And I think the question today is not directed to someone who's still to be appointed. You are already an acting Chief Justice, and you are a Deputy Chief Justice. The response that I was expecting from you was to say, when I leave here, Monday, the process of having those policies will be starting. Can you maybe comment on that?
Well, I indicated that I would be supportive, and I'm quite happy. I think my colleagues who are in the heads of courts who are also candidates here, I'm quite happy to make sure that on Monday I talk to them and say, okay, how do we move? Let's move on this, because I understand it came from one of them, if I'm not mistaken.
Thank you so much for that, ACJ. These two policies, the non-existent of these two policies, it mostly affects women, women judges. And it doesn't look that the whole judiciary doesn't have these crucial policies.
Yes.
Again, the issue that was raised by Commissioner Makwanish, the issue of the language. I heard your response and I respect it, but don't you think that it needs to be revisited so that maybe you can refine it properly the way that you have explained it now, to say that I think maybe it can even give courage to other presiding officers to come out or to write judgment in languages, maybe in Siswati or Isindebele, so that it can not be something that is untowards when we find the judgment which is written in an indigenous language.
No. I think, Commissioner, it may well be that it needs to be spelled out. That the fact that the official language for purposes of court proceedings is English doesn't preclude you from providing a judgment in an indigenous language. Then we talk about how that should happen. So I think that's a fair point that can be pursued.
Thank you. Again, this morning when you were tabling your vision, you also touched on the issue of reserve judgment that are taking long to be delivered. And you indicated that you discussed it with your colleagues and came up with models on how are you going to deal with it. But then my question here is that this is not a yesterday's problem. It has been a problem for quite some time. And you as a Deputy Chief Justice, why didn't you make those proposals at that time, and also now when you are now an acting Chief Justice? Because what I heard you saying was to say when you have already proposed that, and when you are appointed, you will proceed with the proposals. So my question to you is when you are not appointed, will you still proceed with the proposal that you have made?
Of course, yes. Of course, yes, I would. There is nothing that I would do if I'm appointed, but would not do if I'm not appointed. Obviously, if I'm not appointed, I would not do something that I should leave to the Chief Justice. I would not usurp the functions of the Chief Justice, but I would still share with the Chief Justice what I had in mind before the appointment, his or her appointment. And if he or she says, I think it's a good idea, let's proceed, then I would do so. But With regard to the fact that I only made those suggestions recently, you must remember that when I was in the commission, while the public hearings were going on, I was not sitting in court. I was not part of the panels. I was not sitting in court. The Chief Justice was there. I did say that the Chief Justice shared with me and consulted with me on certain issues, but I was not part and parcel of the justices who were sitting in matters. I only came back in July this year after the Chief Justice had left. So my mind was on the work of the Commission during the past, 3.5, 4 years. Yeah.
Thank you, ICJ.
Thank you.
There's a question that I ask other candidates. It's the issue or the idea of having sexual offense matters and family law matters to have specialized courts where we are going to have well-trained judges and magistrates in that field. What is your idea on that one?
Well, I would not be opposed to that. Anything that could make sure that there is improvement of service delivery, including making sure that there is additional training or there is specialization, those are things that are close to my heart.
Thank you, ACJ. ACJ, my last question. There's an objection here. You are going to be appointed as, if you are appointed as a Chief Justice, you are going to be the chairperson of the what is JCC?
Judicial Conduct Committee.
Yeah, there's a objection here from Zakele Kumalo, who seemed to suggest that you are easily influenced. You were influenced on an outcome of the complaint that he lodged against one of the judges, and you were influenced by one of the senior judges. What is your comment on that one?
Well, I must confess I don't remember that complaint, but if that is what it says, he is very mistaken. I have a good track record. I told the commissioners this morning how when I was acting JP or a new JP sitting with senior judges, how I disagreed with both of them and wrote my own judgment. I can give many examples about my independence. Let me tell you about a judgment that is referred to in the documents here, Engine. That's a judgment which I wrote and disagreed with the Supreme Court of Appeal on the approach they had taken on a certain matter, and the matter raised both labor matters and administrative law when I was still Judge President of the Labor Appeal Court. The Supreme Court of Appeal had given a unanimous judgment with 5 judges and said the approach that the Labor Appeal Court had been adopting since I became Judge President in regard to the assessment of whether a dismissal is fair or not was a wrong approach, and the correct approach was the so-called reasonable employer test. And I was convinced that the Supreme Court of Appeal was wrong, but I knew that I was bound by their judgment and I had to implement it. But I felt that it was appropriate for me to articulate correctly in detail why their view was wrong. And I went back to where the reasonable employer test originated from, namely in England, in a judgment by Lord Denning. I said, this is where this reasonable employer test came from. that judgment which talked about it for the first time was based on a specific statute. We in South Africa don't have a statute which has similar provisions. This test was imported into South African labor law wrongly by this judgment and that judgment and that judgment. If you look at our statute, it has no place for a reasonable employer test. And I looked at international jurisdictions. I wrote that judgment. The SCA judgment was then taken on appeal to the Constitutional Court, and the Constitutional Court upheld my approach and said my judgment was correct. So I'm just saying here was a case where a higher court had unanimously said we were wrong, and I believed that we were right, but I also was disciplined that this is a higher court, we must implement their decision, but on a point of law, they were wrong, and I said so, and the Constitutional Court upheld my judgment.
Thank you, ACJ. Thank you, Acting President.
Thank you, Commissioner Shabangu Mndau. Professor Slema.
Thank you, Acting President. Justice Zondo, when you just said that you haven't been on the bench for the past 4 years, it made me wonder how much touch have you lost with the bench by being the chair of the commission? How much of the challenges that your colleagues are experiencing can you relate to? And the reason why I'm saying this is in your vision, you didn't really point out anything that you have, it seemed, picked up yourself.
Well, thank you. Well, really, the big issues in our court, in the context of what we are talking about, is the reserve judgments and our delays in disposing of new applications. We have had meetings, so we have had discussions. Since I came back, I've had a lot of meetings. But also when the Chief Justice was still around, as I said, he talked to me about some of the issues we discussed. So I certainly did not sit in matters, but I did not divorce myself completely in terms of knowing what is happening. The Chief Justice and I talked very frequently about what is happening. But in terms of the delays, I may not have been fully conversant, but I might have known just generally this, we seem to be taking long without knowing the details at that time. So I have been back at the court for the past 7 months. I have been interacting with my colleagues, so I believe that I am in touch with them. I'm in touch with, I can relate to what is happening.
It was put to Justice Meyer 2 days ago, and I also asked a question concerning the quality of the judgments, not only at the SCA, but also at the Constitutional Court, but precisely or specifically concerning the judgments coming from the SCA that is being appealed against or appealed to the Constitutional Court. Commissioner Madonsela asked about the issue of legal certainty, the fact that so many of the SCA's judgments are overturned by the Constitutional Court. How do you see the approach that should be taken by the Chief Justice, if you were to be appointed, to assist in helping the SCA and other courts, as well as the Constitutional Court, to get the quality of their judgments at the level that the South African judiciary should be functioning?
Thank you, Commissioner Slema. You know, the issues of the quality of judgments and the delay in handing down judgments, they relate to each other at some level. because sometimes the delay is because somebody is trying to write a very good judgment, and then a delay happens. And that judgment might, in the end, when it has been written, indeed be very good and be hailed as very good. But if it has taken beyond a certain time, then there is a concern to say, but it's taking too long. So the question of delays in handing down judgments and the quality, there needs to be a balance that is struck. Striking that balance is not mathematics, it's not easy, but at least we should always be alive to the fact that we have an obligation to give judgments that give guidance, that ensure that there is certainty in the law, but at the same time, we must not delay unduly in handing down those judgments just because of considerations of wanting to write a super judgment, if I may call it like that. It's a striking of the balance. My own, excuse me, my own view is that certainly the Chief Justice in the case of the Constitutional Court needs to keep a close eye on that. We had a discussion, myself and my colleagues in the fourth term last year, in terms of which, for example, we agreed that if a certain period has lapsed and a colleague has not circulated his or her first draft judgment, they must report themselves to the Chief Justice so that the Chief Justice, the two of them, can then see what needs to be done. And obviously, issues of how long it would take after that become important. But at the same time, quality is important. But so SCA, I guess, is the same considerations that they would have. But the Chief Justice would play a role in terms of these issues having to be discussed at the heads of courts to say, there is this concern, what do we do to make sure that, one, we don't delay unduly in handing down judgments, but at the same time, our judgments should be of the right quality.
And my question doesn't really relate to quality in the sense of whether it's written well, or it's more related to having the law and the legal position correct. Because often one finds, and it's quite alarming, when you read a judgment, that the law is applied incorrectly, that the law is stated incorrectly. So that is more my concern.
Well, then in that event, it's a question of the care that is taken to make sure that the law is stated correctly. It's a very important point, a concern you raise, but it just means that in the case of the Constitutional Court, all judges, not just the scribe, need to make sure before the judgment is signed off that it states the law correctly.
Thank you, sir. I'm not going to take it any further. Thanks, Chair.
Thank you, Professor Slema. Commissioner Malema.
Thank you very much, Acting President. I won't take long because my eye is acting up. When I woke up this morning, my left eye was closed. So from time to time, it keeps on closing itself. So the sooner we finish, the better. Acting CJ, now we've got letters from the administration where a minister writes to you in response to the letter that was written to him by Chief Justice Mbuyiseli. And he indicates in this letter that Chief Justice Mbuyiseli had recommended J.P. Madondo and Judge Rogers And he makes an argument that you must give other JPs an opportunity to act, and so on and so on. And then later on, he says to you, please put Madondo and Mlambo to act, without giving any reason why you should drop Roger, who was suggested by Chief Justice Mukhwe. Then you respond to him, and then you indicate that, you have received the letter, and you give the background, and you also demonstrate to him that his argument that other JPs are not given an opportunity is neither here nor there, because the following people you give a long list of people who have given an opportunity, including the deputy judge presidents and all of that. And you say that you cannot appoint JP Mlambo because it's late in the letter there. That point has been made. And then from there, what shocks me is that then when you go to appoint, you appoint JP Mlambo and I think
Advocate or Judge and Terralta.
Yeah, yes. You appoint the two, and you have abandoned that argument which you put earlier cogently, that this JP has been given an opportunity, declined before, but it's not true that JPs are not given an opportunity. Here's a long list, and it's also late. Then you leave that argument, you go and appoint Unterhalter and JP Mlambo, and Rogers and Madondo are completely left off.
No, they were not left off.
Yeah.
They acted.
Yes.
They acted.
This is a separate thing.
Yeah. This is what happened. It's different times.
Yes.
So DJP Madondo and Judge Rogers acted. Judge Rogers just finished mid-January, actually, acting.
Yes.
Judge Madondo finished at the end of November, and he had indicated to me that he was not going to be available beyond November.
Who was that?
Judge Madondo.
Okay.
So I probably would have extended his acting appointment just like I extended Judge Rogers' one. But
Yes.
I didn't extend it because he said he was not available for an extension beyond the end of November. But as it turned out, he actually fell ill earlier.
Yes.
And by the end of November, he was not in court, he was in hospital and so on and so on. So they did act. But what I had said to the minister, and I must just say immediately that I haven't had a look at my letter to refresh my memory,
Yes.
but based on my recollection, I had refused to appoint Judge Mlambo at a particular time, and for the reasons that I'd given. But my approach was not that I would never appoint him. My approach was that sometime in the future I can consider him, which is what happened. Yeah.
So we are in agreement that it is not illegal for a minister to suggest that so-and-so must act, but it's something unheard of.
Well, I said I don't want to say anything whether it's legal or not, but I said it's certainly not something that had happened before as far as I know.
Okay. Now, I want to come to a different subject. This Fraser.
Before I beg your indulgence, Chair, before Honorable Malema gets to the different subject, I want to make a follow-up without confusing ACJ. Would you allow me to do that, or do you want him to finish the second subject first?
Would it not be proper because it's his turn?
Okay, it's okay.
He must.
We have
Oh, no problem. I respect
Yes,
that.
thank you.
I apologize.
We have all waited, Chair, for people to finish before we make follow-ups. So I don't know why is the blood running fast now. Now, Fraser, my worry with Mr. Fraser is that, you know, as head of intelligence. There is a room there at intelligence place called Musanda. It's a room called a grabber room, where all of us, they've got our things that we communicate on phones, emails, anyone they want, especially if you are a judge or a high profile, anyone they so wish to listen to, they listen to. And here is a guy who says, I want to come there and tell you about judges and all that. Did you fear he's got something on you, perhaps, that you said this guy must never ever come here? That we are going to be embarrassed here and won't have capacity to stop him? Because I will tell you, if I was the chairperson of a commission, I will be very interested to hear from a former head of intelligence who's implicated in 9 billion.
Well, I certainly was not scared of anything like that, Commissioner Malema. And if I was scared of anything like that, I probably would not have adopted the approach that I adopted in April when his lawyers came before me, moving that application that I should order the Minister of State Security and the SSA to release documents to them. My attitude was the State Security Agency agrees to let you have access to the documents, and you have accepted. So the natural thing for you to do is go there, and then you must come back. And I simply said, because of where we are with the proceedings, I just want you to know that when you do come back, we will have to look at what the situation is like at that time and take it from there. So I was not concerned, but for what it's worth, Commissioner Malema can say that I tell people who speak to me on the phone that they must assume that there are other people listening. Yeah. So when I speak on the phone, I assume that there are lots of people who are listening that without my permission.
Okay. You know, Acting CJ, I'm troubled by this because it's what I'm going to raise in the debate there, that there is no way you will not subpoena a head of intelligence implicated in a 9 billion. I'm not interested in him trying to get other documents to come and help you. That is his voluntary thing. But where he got mentioned so many times, I even lost the count how many times he got mentioned, and so much figures implicating him. You still are not interested in him, and you are fighting corruption. You are trying to expose corruption and the corrupt. Here is a man that worked for the state and worked for a strategic institution which has got a slush fund that not even Auditor General can access it. Gets implicated, we don't subpoena him, we don't compel him. I'm troubled by that. And Wes, he even objects himself. He says, having been implicated so many times, why didn't they subpoena me so that I can respond to these all types of allegations? I'm raising it with you because I'm going to raise it tomorrow during our deliberations.
I think that's fair enough for you to raise it, Commissioner Malema. But I don't think I can add to what I said earlier on, that probably if he had come to, if that what happened when we realized he was not getting the documents had happened much earlier, when the commission still had a lot of time, it may well be that I would have taken a different decision. But we were very close to the end. That is what was problematic.
No, Acting CJ, you are close to the end when he volunteers to come. You are not close to the end when he gets implicated. He gets implicated much earlier.
I agree.
Yes.
I agree.
So the late coming is when he is now volunteering to come and help you. And you say to him, but I've called for this long time ago. You come very late and you are demanding things here and they are not forthcoming. Therefore, I'll have to proceed. On that one, I said, I agree with you. My problem is he gets implicated much earlier. He's
No.
not called.
Yes.
Zizi gets implicated much earlier on 1 million. He's not working for the state. He's in a shack called Lutule House. He gets called from there or come here and explain, why did you get this money? Yet he never presided over any big deal. If I were to have Zizi or to have Fraser, I'll go for Fraser because he presided over the most strategic budget in the department. So that's where my problem comes in because, okay, let's say Fraser, for whatever reason, he didn't come to you and say, I want to help you, like he did much later. It means Fraser was going to be left. Even when he's implicated much earlier, Fraser was not going to be called with also many people implicating him in and when you bring amounts together, it's not me, it's him who says 9 billion. How do you get someone implicated on 9 billion and you are not interested in that person?
Well, let's clear that I don't think it's really 9 billion, but let's leave that for aside. There are certain facts here. Mr. Fraser gets implicated, I think, in June or thereabout in 2020. He comes to the hearing with his legal team. His legal team says to his counsel, says to me, we are going to present our case. But that is now, as far as I recall, I hope my recollection is not failing me here. So they leave the commission, certainly as far as my understanding is concerned, on the basis that they are going to do whatever they want to do and then they will come back. Okay? So we don't have to subpoena somebody who says, I will come back, because they are going to prepare whatever they want to prepare and then come back. So we continue with other matters. And then in March, they do come back. But when they come back with an application to say, Chairperson of the Commission, we have asked for documents from SSA because we want to come and give evidence. They are refusing. Can you please make an order and compel them to give us these documents? So the SSA responds and says, but it's not true that we have refused to give you documents. And they put up correspondence. They say, here is a letter of, I don't know whether 5 August 2020 or whatever, in September. They put up letters. They say, we wrote to your lawyer. We invited you. Your lawyer never responded. So we are telling you now that we will give you documents, but we're not sure what documents you actually want. You would have to come to the offices and you can tell us what documents you want. And then he, in response, says, I accept your offer that I should come and get the documents. So that is when they are before me in April. So I then say, well, in the light of this, it means this application where you want me to order SSA to give you documents must just be postponed because they agree and you agree. So you go and find find the documents and come back. And when you come back, I just want to say, depending when it will be when you come back, we will have to see where the commission is. So we part on that basis. And then he never comes back. And then the hearings come to an end. Before the hearings come to an end, the Secretary of the Commission writes to the lawyers of both SSA and Fraser, effectively saying, what happened about those documents that you were going to meet and agree upon? Mr. Fraser's lawyer does not respond. The state attorney responds on behalf of SSA and says, we've been waiting for him. We tried to set up some meetings. It didn't work, but we have waited for him. He agreed that he must comply with the regulations if he wants the documents. But up to now, he has not complied with the regulations. So that is what we get told. By that time, it's too late. So that's all I can say.
No, that's fine. I still don't agree. I'll take it up with the commission.
Yes, yes.
ACJ, I see that you have extended a courtesy to President Ramaphosa because the commission is the commission of the president, and the office established the commission, and it was President Zuma. Was the same courtesy extended to the former president? Where you go, like you did with the current president. In terms of warm bodies, it's President Zuma who established the commission. Long before all the shenanigans started, the same way, the polite way, you went to the president, you talk to him, you show him whatever, then in the process you say you must come and also testify. Have you tried doing the same thing with President Zuma? President Zuma, that you may not be the president today, but that issue that you left us with is unfolding, is doing very well. At some point we'll want to have you there coming to testify. Because I don't know what was the arrangement or the environment between you and the current president. But courtesy would mean that, you know, that warm type of an approach, brotherly approach to say, well, we're here, and then at some point, please come and do the honorable thing.
Well, I didn't have a meeting with President Zuma, but remember that the current president was, because he was the president, I would meet him from time to time to tell him what was happening in the commission in terms of if there were challenges or if there was to be an extension. So it was one of those occasions when I told him. With regard to President Zuma, I think we wrote a letter to him or to his lawyers. I can't remember whether first to him or to his lawyers straight away, and invited him to come and give evidence. He took quite some time before he made up his mind whether he was going to come or not. Ultimately, he agreed to come. But I can't remember whether after he had agreed or before he agreed, he raised an issue and said, in terms of what rule was I inviting him to come? And I think my response was that this was a courtesy. We were not necessarily going to issue a summons. It was a courtesy. When he did come, he still made an issue about the fact that I had extended the courtesy and not said there should be a subpoena. I had simply written a letter. They made an issue. It was on TV. So they made me get the impression that they did not want me to act in any way other than in terms of the rules. But I'd taken the view that I should do that courtesy to him. I didn't know that he wasn't going to like it.
You have been to President Zuma's apartments or hotel rooms in Durban more than twice through your own statement that you issued or read in the...
Please just repeat, I didn't hear it.
You have been to President Zuma's hotel in Durban more than twice. That's the account you gave in the statement that you read during the recusal application on his invitation.
Well, I know that I remember one time, I don't know if it's twice, I didn't refresh my memory on the statement, but if you say that's what it says, then it must be so.
Yes, and then it was when you were a judge, and then President Zuma invites you to his hotel room twice or more than that, and then you go. Why was he inviting you? What were the issues?
Well, I haven't, does the statement say it was a time when I was a judge? Maybe.
Yes.
Okay, all right. Well, let me put it this way. We knew each other, Mr. Zuma and I. So I think he called, or I got a message that he would like to see me. There was, as far as I'm concerned, no reason why I shouldn't agree to see him. I went to see him. But I can't remember, because that was much later, I can't remember what the issues may have been on that occasion. That was quite a long time ago.
No, acting CJ, as a judge called by such a prominent politician to his hotel room, it can't be a matter that you can easily forget. It's a memorable thing. I mean, I remember the day I met Mandela at his house. He said to me, if you want to lead society, you have to cut your stomach. It's too big for a youth president to be a president with a big stomach. And I had to make initiatives to meet that demand. So it's a memorable thing. I can't forget that. You can ask me of any prominent person I met when I was young. I remember that. There's no way I'm going to accept that explanation.
Mr. Commissioner Malema, I may have remembered if I was meeting President Mandela. President Zuma, I knew him, we had known each other. As I say, it might have been more than 20 years ago when that particular meeting happened.
Then you went to meet Zuma, President Zuma again at his there was one time when I also asked for a meeting with him about the 13th or 14 years ago, when he was still out of government, and I met him in his forest town house in Johannesburg. On that occasion, I wasted to raise with him a matter that I considered of public importance. That was at his house in Forest Town. What is this matter of public interest?
Yes, no, that I can tell you what it was. Firstly, because I remember it, but also because I had a look at his affidavit in response to that statement, and I know that based on what he said in his response, he would not be taking a view that I should not say what that matter was. In a different situation, I might have been concerned whether if I went and had a private meeting with somebody, I would have to then say what we discussed in private. But because he has taken the view which I understood to be that he doesn't mind if I mention it, then I'm going to mention it. This was, I think it may have been 2008. Unfortunately, I didn't get a chance to check newspapers so I could refresh my memory. What had happened is that there had been some event or function where both you, Commissioner Malema, and Zuma were together somewhere. And you spoke at that event. Might have been, I don't know if it was a media conference or whatever, I have no recollection, but you spoke, and I think he was sitting next to you. And if I recall correctly, that's the occasion when you said you were prepared to kill for him. I was concerned about that statement insofar as it could bring violence in the country, particularly in terms of the atmosphere at that time. it troubled me, but I was more troubled by the fact that when he stood up to speak, he did not say anything to you to indicate that this was not right, to talk about killing for somebody in the context of whatever the issues were. After some days, I thought, well, I know him. What if this could end up leading to quite some violence? Maybe I should ask him if I can see him and talk about my concern. I made arrangements and he agreed. I went to see him. I told him that I was very concerned because regions, provinces, even a country could be thrown into a lot of violence if leaders do not speak to their supporters and dissuade them from making any statements about violence. I talked to him about the violence that we in KwaZulu-Natal had, which he knew. I think I may have spoken to him about violence in other countries. And I indicated that I was concerned about it as a citizen. I was concerned in case we ended up with violence. I thought that he should have spoken to you. He listened to me, and I give him credit. He understood, but my recollection is that he said he had not spoken to you in public, but he spoke to you in private. That's my recollection. I was simply concerned about the possibility of violence.
I knew that that was the case, and I viewed that as a pure political interference by a judge, because that was a statement made in a political rally. And you left, you went to meet President Zuma to discuss my political position as a judge, and you proceeded to sit on matters where the organization I lead, and I looked at you, the organization I lead came to litigate against President Zuma. You have never indicated to court that you knew President Zuma like that, to a point where you can even discuss political issues with him. On 2 court cases that we brought before the Constitutional Court, you said there, never declared like everybody declares here that they know you in this way or that way. You never said, one of the respondents in this case, I know him like this, to a point where I had a political discussion with him about the leader of this political party. Don't you think that that was unethical for you to, one, to go and discuss a political statement with a politician as a sitting judge, 2, to go and listen to court cases involving the 2 politicians without declaring that you know the other side of the case?
Well, no, I don't share that view, Commissioner Malema. This was a concern about a statement made by you at the time, at the age at which you were. As a citizen, I was concerned, and it didn't mean that I had nothing against you. My concern was that he should have dealt with the matter in a certain way, because we should not have violence. And I didn't have anything against you, so I wasn't going to be conflicted. I don't know how many years later in hearing a matter involving an organization that you formed many years later, I wasn't going to be conflicted at all.
But ACJ, here is a story that you go and discuss another politician with another politician, and later on, it comes out that this judge who's sitting here has got strong views about you. And he sits here to listen to an affidavit that is signed by you. You are the face of this case. Don't you think that it is actually not in the best interest of the judiciary and for the judges to go and discuss other politicians? Because if you're bringing age, at the age I was, it's immaterial to me. I'm a politician, I'm a president of an organization even at that time. I was not a leader of a crèche. I was a political leader of an organization with rich history in this country. And for you to go as a judge to discuss another politician with another politician, that amounts to bringing the judiciary into disrepute. Because now when it comes out is, this judge holds an extreme political views about you. It doesn't matter how many years after. And when we say why, how? No, he drove all the way to come and talk about you, and he was a sitting judge. Is that not, does that help to enhance the good image of the judiciary, or in what way does it help to improve the good standing of the judiciary in society?
I don't think it creates a problem at all, Commissioner Malema. I think as a citizen, I am entitled, if violence maybe is threatened and I know somebody who can do something to prevent people being killed and so on, I think I'm entitled, even if I'm a judge, if I know that person, I'm entitled to go to that person and say, please, we don't want violence. If there is violence, ordinary people will suffer, will be killed, and of course they might not agree, but I think as a citizen, I'm entitled to do that. And I've never held any strong views against you, Commissioner Malema, political or otherwise. Actually, I have respect for you. So I've never had any strong views against you. You have a certain way of dealing with issues, a certain way of dealing with matters. Sometimes some people don't like it. Yeah. Thank you.
Thank you, ACJ. I've got a very serious problem when I raise issues and I get to be loved by everyone. I'm not money. I will never be loved by everyone. And those who brought me up politically were never loved by everyone. Fought for this country, got ill-treated to their graves. So I'm not in a business of trying to impress everybody. I'm here to pursue that which I think is right. Others will be happy, others won't be happy. It is their own baby to feed Malta Bella. I'm not in that business. Now, I want to go back to the earlier thing of meeting President Zuma in the hotel. This had to be so because we will normally interact when we meet at the opening of Parliament or other government or state functions. However, there were 2 or so occasions when Mr. Zuma was not in government, when I asked for a meeting with and I agreed to. When he asked for a meeting with and I agreed to him, I think that this would have been somewhere between 2005 and 2007. He was staying in a hotel in Durban and I met him. There was one time when I was also asked for a meeting with him about 13 or 14 years ago when I was still out of government. This is what we spoke about. So you remember that you met him between this and that in a hotel in Durban twice. I accept that Zuma is not Mandela, but when you come from KZN, Zuma is the Mandela of KZN. That's why you even speak about the role he played in dealing with violence in KZN. There's no way you can be called by President Zuma twice in a hotel. You remember the years, you remember that it was in a hotel, you remember he was not in government, you don't remember what you were discussing with President Zuma at that time. I know, but there is a rule here that you don't give people, you don't raise issues that we didn't raise with you before. But you, on your own volition, please, ACJ, take the country into confidence. President Zuma asked to see you twice in a hotel. You agreed to go and meet him, and you remember all of those details. The only detail in 2 meetings you don't remember is why President Zuma wanted to meet you.
Well, I certainly don't remember them, Commissioner Malema. The one that I remember, I've told you, I've told the Commission the one that I remember.
ACJ, I'm worried that it becomes very easy for you to descend into the political arena. One is these meetings that you had with President Zuma to discuss politics. 2 is these meetings that you have with ease with President Ramaphosa to discuss this and even go beyond of discussing how he's going to appear and all of that. And anyone who says Ramaphosa's appearance was staged, I'm tempted to agree with them, because you met him before, and then you now have a press conference to engage politicians in public, descending into the arena. Are we going to have a Chief Justice that gets easily available to meet politicians at their own comfort? We don't know what gets to be discussed there, and when we ask, they don't remember. Will that not even put this judiciary in a more crisis than it is now? Because research has been presented here that people are losing confidence in the judiciary. With an ACJ that visits politicians with ease, I mean, I heard others saying it's easy for you to call a minister and all of that. Those things of ministers are insignificant. We're talking presidents here, so we're not talking those ministers, this and that. Presidents, whereas those that are implicated in what you are presiding over. You meet them with ease. You discuss with them with ease. It shouldn't be easy for any judge, that's my view, to be available to meet a politician. And shouldn't be easy for any politician to be available to meet any judge, unless they are prepared, when that matter is exposed, to disclose publicly with ease what was the meeting about. I'm living here with discomfort that you are a sitting judge, you met a high-profile politician in a hotel twice. You remember all the details. The only thing that cannot be remembered is what was discussed. I don't think that helps to get you to be the CJ of our country if such small details cannot be remembered.
Commissioner Malema, I think you have made your point. Acting Chief Justice admits to having had those meetings, but cannot remember exactly what was discussed at those meetings. He explains why he had to see the president of the country on official business, as I understood him, about the work of the commission established by the current president's predecessor. I think you have made your point. If there is anything to be said about this matter, it can be said during our deliberations.
I accept that, Chair.
Thank you.
Let me make the last point on a different matter. Acting CJ, you are now the Deputy Chief Justice. And when we appoint you as a Chief Justice, as a proponent of transformation, how does that help with regard to transformation? Which box are we going to tick when we are given a form of transformation and say, hey, his appointment, which box does it tick here in terms of what you are trying to do with regard to transformation? And exactly in the same vein, shouldn't we hang our head in shame as a country and as black men and African men who were oppressed together with women and African women being oppressed 3 times than us, that we have a judiciary for almost 30 years, which has never produced a female Chief Justice. Not because he's a female, but because she's qualified, and we've had so many women who are qualified to be the Chief Justices of this country. But till to date, we have never had one, even with the candidates that the President has presented before us. Just gave us one option and never said to us, there are more than one woman to be interviewed here, so that we can be spoiled of choice before we turn 30 years into democracy to have a female judge president. What does your appointment help us with in terms of the transformation of the judiciary? I think that is my question. And my last question, I won't even come back.
Well, Commissioner Malema, I am here because it seems to me the President wanted to have a choice when he makes a decision as to who should be the next Chief Justice. He considered that I am worthy of being included in that list. I consider that it's good that this commission should have also an options and a choice. Ultimately, what the President decides, it will be his prerogative. But he will look at whatever factors that he needs to look at, including child transformation, and make his decision. In terms of my candidacy, my CV is before you. The questionnaire that I've filled is there. My track record is there as a judge, as a leader. But the decision is that of this commission and is that of the President.
Thank you, ICJ. Thank you, Chair.
Thank you, Commissioner Malema. Commissioner Dodovu.
Okay, after Dodovu, after Commissioner.
Thank you very much, Acting President. Again, good evening, ACJ.
Good evening, Commissioner.
Yes, I will only ventilate issues which were raised in this session by Honorable Malema, and not any other thing else. I had the occasion to look at Section 175 of the Constitution as it relates to the appointment of acting judges. Having looked at this provision of the Constitution, I pick up the following issues, and I want you to tell me whether I'm right or wrong. Firstly, that acting judges, including the Deputy Chief Justice, is appointed by the President. 2, that the Minister has got the power in terms of this provision to recommend the appointment of the judges. And 3, that the Chief Justice must concur with the recommendations of the minister. Is this the understanding that you have?
I think
in
your
this
understanding
respect?
is correct.
It's correct.
Of what the Constitution says, yeah.
If that is correct, does it mean that your assertion is not correct, that what the minister was doing was abnormal? Because, as I understand, he was within his right as provided for in this provision of the Constitution.
Well, you talk about what's provided for in the Constitution and you talk about what's abnormal. You may remember in my exchange with Commissioner Malema, Commissioner Malema was very careful when he asked me a certain question. He said, was it the norm? Which is different from, was it lawful, was it legal? And I said, if you ask me, was it the norm, I'm saying it was not the norm. And later on, I said, I don't want to get into the question whether it's legal or not.
I understand that and I respect that, but my take, and I want you to correct me if I'm wrong, my take is, if it was the Chief Justice or the acting Chief Justice who was recommending judges to the President, that was wrong, that was incorrect. And the correct procedure would have been that the Minister is the one who recommends and the Chief Justice must concur in terms of the provision of 175 of the Constitution. I'll tell you why I'm raising this particular point. When the Minister recommends, in my respective view, he doesn't have to provide reasons why he's recommending this and that person, because in terms of this provision, as I understand it, any judge can be recommended by the Minister. And for me, I find it odd that any insinuation can be made that whenever the Minister recommends, it will be unlawful or there will be a motive in that particular respect. Do you agree with me on that?
Well, the recommends that is provided for in the Constitution is not the Minister recommending to the Chief Justice. It's a recommending being made to the President.
Yes.
Yeah. He was not recommending to the President. He was suggesting or recommending to me. But I have said nothing beyond simply saying it was not normal. I've not said it was unlawful for him to do it or anything like that. I simply said it was not normal. And it was not normal simply because the way it works in practice is that it's the Chief Justice who initiates and talks to judges and judges president to be available for acting appointments. And when they've agreed, he then writes to the minister to say, these are the judges that I would like to be appointed as acting judges in the Constitutional Court, and I would like you to recommend them to the president. And the minister then says, I will recommend, or if he has some issue, he might raise some issue. But normally, that's how it normally happens.
If I say that normality you are explaining, it is a norm, yes.
Yeah.
A norm that you are explaining,
yes.
It is not, it's a wrong norm. It's not the way it's supposed to be. I want you to dispute that.
But you see, that's why I keep on saying what Commissioner Malema and I were talking about was what was the norm. And when something that is not the norm happens, you notice.
Yes, okay, yes.
But we were not talking about whether it was lawful or not lawful.
Let me tell you what I see here. I see, and in these correspondences that I've read, I see a minister who was correcting a practice that was perpetuated, and that practice was wrong. Because under the normal circumstances, and in terms of this provision of the Constitution that I see, it is the president who must appoint an acting judge on the recommendation of the minister after the minister has obtained the concurrence of the Chief Justice.
Well, I did say I was restricting myself to what was the norm and not to what was lawful and what was not lawful. I'm not sure that I should say anything further.
Yes, no, it's okay.
Yes.
Yes, I think we have extensively exhausted that matter. The second matter, the issue of of you meeting presidents, whether it's President Zuma or it's President Ramaphosa. It's common cause that you know that President Zuma, other than being the head of state, was the president of the ANC, which is based in Luthuli House. Yes, I make that assumption that you should know that he was the president of the ANC that was based in Luthuli House. Have you been to Luthuli House?
No, I've not been to Luthuli House.
Do you know where it is located?
Yes, I know where it's located.
Have you ever seen a shack in Luthuli House?
I think on that note.
No, it's okay. I want to lay that matter because the Luthuli House that I know is a revolutionary house, and I remember even Commissioner Mlambo emphasizing that this is a revolutionary house where the Luthuli House is. Thank you very much.
Ungayingeni ACJ. Ungayingeni.
Thank you, Honorable Minister.
Thank you. Okay, people, I think it's late now. Let's try and
I thought I was recognizing the minister. Because he had raised.
I said I'll speak after Dodo. Sorry.
Because he had raised, but he's busy with his
but I raised
electronic
before him.
device now. Perhaps you may go ahead, Commissioner.
In fact, even for the reason of what I'm going to say, it might be better for him to come afterwards. All right. Unfortunately, I can't talk about the other matter of the recusal.
I understand.
Because I'm conflicted twice. It's one of those strange things where I was briefed by both sides. You briefed me to appear for you.
Please, Commissioner.
And I was already
just
briefed by the
say
other
what
side.
you want to say.
No, that's what I want to say, Chairperson. Please, I cannot be suppressed at this stage. Okay. So, and I'm saying that for a particular reason because it's relevant to what Commissioner Malema was saying. That you had approached me to brief me in the recusal matter, but I was already briefed by the other side.
Yes.
Thank you. That's important.
Thank you.
Now, I want us to talk about the letters. As I say, I can't speak about that other matter. And please, ACJ, I don't mean any disrespect. I'm just trying to save time, so I'll ask almost yes and no questions.
Okay.
Is it my understanding that from this correspondence on the 30th of April 2021, CJ Mogoeng wrote a letter to the minister or the president asking for the acting stint for Judge Madondo and Judge Rogers?
I haven't seen the letter.
Yes, you can take it from me.
Yeah, but understand that there was some letter. What date it was, I don't know.
Okay. Well, it says in his letter dated 30th April 2021, this is from the minister.
Okay.
And he's here. It says in his letter dated 30 April 2021, Chief Justice Mogoeng recommended Deputy Judge President Madondo and Judge Rogers for appointment as active judges of the Constitutional Court. Right. Now, this letter is dated 0207.
Sorry, Chair. Sorry, Commissioner Mpofu. The letters are there with the ACJ.
Oh, the last time there was only one.
Yes.
So I think they've put, you see, Commissioner Madam, I think you asked me too many questions. I didn't see them put them here. Okay, thank you. Thank you, Commissioner Malema.
All right. Now, this is unimportant. I'm just tracing the history of this thing. 30th April, Chief Justice Mogoeng asked for Deputy Judge President Madondo and Judge Rogers to act. The minister responds on the 2nd of July 2021 to say that I've seen this letter from CJ, and he says, having reflected on this matter, I suggest that consideration also be given to judges, president for appointment and so on. You've dealt with that. And then he says later, in the circumstances, I would therefore recommend that Judge President Mlambo be one of the 2 judges that are submitted to the president for consideration. It is my view that Judge President Mlambo be recommended with Deputy Judge President Madondo for the upcoming stints. So in summary, what the minister was saying is that Chief Justice Mogoeng has given me 2 names. Drop Rogers J and replace them with Mlambo JP.
Yes.
Thank you. Right. Now, then you write back on the 9th of July and you say, no, it's too late, or words to that effect.
Yeah.
In other words, there's no concurrence in terms of 175(1).
Yes.
So let's draw the line. That's the end of that. Then on the 8th of November, 2021, you write and say that you ask the minister to recommend to the president that Judge President Mlambo and Judge Unterhalter act. Right. Now, obviously, this is still inspired by the request of July. I'm sorry. If Mr. Matantana called you a witness, I'd rather you say yes, not so that it's on the record.
Okay, just repeat what you said.
No, I'm saying on the 8th, you write on your own to make that recommendation that I've mentioned. But clearly, it's still inspired by that request, the earlier request.
But my recollection, I haven't refreshed my memory on my own letter to the minister in response to his one.
Yes.
But my recollection is that I had refused to
on the 9th of July.
Earlier, yeah. But my approach, either at that time or later, my approach was that did not mean I would never give him a chance. So later on, when a chance arose, I gave him. And part of the reason why I thought I should give him was that it appeared that he could make himself very available very quickly, whereas usually, particularly with judges president, you need quite some time. And at that time, when I was looking for somebody, I think it may have been towards the end of November, or I don't know whether December or whatever.
No.
Yeah.
I think we're saying the same thing.
Yeah.
So when you made that recommendation, you were still mindful of the minister's request?
I don't think I had forgotten it, but I don't think it was playing a role in my mind. I think what was playing a role in my mind is it looks like he can be available at short notice. So rather than try and look for somebody at this time of the year when it's going to be difficult to get somebody, let me go for him, because after all, we previously wanted him.
Yes, no, but why did it look like he might be available? Because of the minister's letter?
Yeah, maybe,
Yes.
yeah, I think that is true. Yeah.
Okay, now, the issue then is that I want to, Commissioner Dodov say it's lawful, and you've said that you're not questioning its lawfulness. What you're saying, I think you used 2 words. It was not the norm and it was unusual. Yes. Now, I just want to demonstrate that section of the Constitution says the following. Or let's start here. When the minister wanted you to replace Judge Rogers with Judge Mlambo, that was not, at that stage, that was not the same thing as there being a vacancy in in the Constitutional Court. In other words, he didn't want you to fill a vacancy, he just wanted you to substitute.
I think he wanted me to substitute. Yeah.
Yes.
Yeah.
Now, the section makes that, that action was illegal. I'll try and demonstrate. I'll ask you for a comment of the minister. Because it says the president may appoint a woman.
Commissioner Malema said, "Ngingayingeni."
Okay, yeah, yes. No, that was the Lituli House, the shack story. The president may appoint a woman or a man to serve as an acting deputy justice or judge of the Constitutional Court if there is a vacancy in any of those offices. So, I don't, but what I will argue at a particular point is that there was those conditions in the Constitution did not exist because there was no vacancy. This was a substitution, which is completely illegal and against the Constitution. Thank you.
Well, the one thing I can mention is that the two, Judge Rogers and Judge Madondo, had not yet been appointed. So it means the vacancies in which they were supposed to be appointed still existed.
No, I understand. But what I'm saying is that the minister was not, in his conduct, he was not filling a vacancy. He was substituting one of the names that Chief Justice Mbuyiseli had put for those vacancies.
Okay.
Yes, thank you.
Hey.
Are you done, Commissioner Mpofu?
I'm sorry. Thank you. Thank you. Thanks for your patience.
You are now leaving me in the less.
Thanks for your patience.
You have served your purpose.
Thank you, Acting President.
Honorable Minister.
No, I don't agree with Commissioner Mpofu's interpretation. There was two vacancies when we exchanged the letters. Yes. But what I just want to bring for the benefit of the public is that I think Commissioner Malema had raised that when we exchanged these letters, this process had already started. And these letters clearly demonstrate that it was around June, from April, that this process had not yet started. Honorable Malema had raised that he wants these letters so that it can demonstrate that when I wrote the letter, the process for the nomination had already started. So I'm raising the fact that these letters do clarify that this process had not yet started because it was around April, June when we were exchanging these letters.
Yeah, well, certainly I only got involved from July, but it was I think it was before the nominations of candidates for Chief Justice when I received your letter and when I responded to your letter.
Oh, okay. Yeah, there is the issue of the phone call, acting Chief Justice. I remember you were also not sure. I also did not remember very well, and hence we had to remind each other with these letters.
Yes.
So one of the issues I had raised earlier on was that whereas the issue of the JPs acting was also an issue, when we spoke on the phone, I raised the issue that almost all the JPs were afforded an opportunity, as you were stating, to act. And there is an outstanding JP that is not afforded the same opportunity. Shouldn't you consider this kind of him to come also forward?
Well, let me repeat. The sequence was as follows. I received your letter before we had a telephone discussion. So I first received your letter. And before I could respond in writing, I phoned you.
Yes,
and,
I agree.
Part of what I told you at the time was that the particular JP you are talking about has previously been invited to act in the Constitutional Court and he declined.
Yes.
You know. And I remember you even said,
with your
he declined or
indulgence,
something
acting
like
chairperson, I just want to, on that point, that when we spoke on the phone and when I wrote you the letter, I was not aware of the fact that he had previously declined.
I think you
must
became aware.
Be right. I became aware when you told me on the phone.
Yes, no. When I spoke to you on the phone, your reaction suggested to me that you were surprised. It was something you didn't know.
Yes.
Yeah.
No, that's fine. Thank you, Acting Chairperson.
No, Acting
Thank
Chair.
you, Honorable.
Acting Chair. Please, we shouldn't do that. We shouldn't allow a situation where we use this platform to mislead the public. The letter that the minister wrote to you says here, having reflected on this matter, I wish to suggest that consideration also be given to judges, President, for appointment as acting judges in the Constitutional Court. Now he comes and says, no, the impression I got is that others got opportunity. It's only this one that didn't get an opportunity. Can you give him an opportunity? When he first generalized it, and then after generalizing it, he zoomed it to an individual. And then you gave him a coherent response by giving him the list of all those who have acted before and say the matter you are raising is incorrect. But then he uses this generalization to come to this one individual. Yes. Not that he was looking for an individual who was isolated from others. No.
Commissioner Malema, we've got the letters. We can debate the import of those letters at the opportune time. JP Tlaleti.
Thank you, Acting President. We do have the letters, we'll see the import, but there appears to be some verbal discussions. Can I perhaps request the ACJ to read these letters before he leaves so that if there's anything that he might need to add emanating from the verbal discussions, it can be corrected or facts must be clear. Rather than when he's here, he's not here, then we come up with interpretation and say this is what you could have meant. But let's give him an opportunity to go through these letters, because what is going on is between him and the minister, this and this and this, and then it generated into a dialogue. You see, please, that will be my special request. Thank you.
Thank you, JP Tlaleti.
Chair, I think if I am to read them and I look at the time, it would be better if I know exactly what the issue is. Commissioner Malema earlier on said his issue was to determine when it was in relation to the opening of nominations. That's easy to check if that is the point, but it depends what other point we are pursuing.
Yes, Commissioner Malema.
No, my point is that this process of this individual recommended to you started once the process has started.
Yeah.
And this is what happens, ACJ.
Yes.
CJ Mukwe writes to them. They don't respond. They wait for him to go. Now they know that the CJ is gone. Their process, you are now acting. We're going to look for ACJ. Then they start responding to Mukwe's letter.
Acting Chairperson, that is a lie. It's a blue lie, what Commissioner Malema.
No, but don't say I'm lying. What do you mean I'm lying?
It's a lie.
No,
It's
don't
a
say
lie.
I'm lying. That is
No, it's
disrespectful.
No,
to
it's
say
lying.
I'm lying, it's disrespectful.
No, it's lying. It's
But
lying.
if you are going to allow him to say I'm
lying.
lying, it's wrong. You see? I'm on a platform here and I'm not going to be called a liar here.
Chair, take charge of your meeting. Chairperson, take charge of your meeting, please.
No insults, please.
Yeah, I can't say I'm lying.
Honorable Minister, I haven't recognized you.
No, he must protect me, Chair.
I'm raising
He
a point of
cannot just
order.
come in and say I'm lying.
I'm raising a point of order.
If he's going to degenerate this thing because he's a minister, it's not going to work here. Not
Mr.
with
Malema,
me.
Mr. Malema.
It's not going to work with me.
Mr. Malema, please make your point.
But protect me. He says I'm lying. Protect me. He's insulting me.
It's out of order, Chairperson.
But he said I'm lying. Out of order is something else. He said I'm lying. He must withdraw that.
Yeah, no, I withdraw the lie. It's out of order.
Now, ACJ.
Honorable Minister,
It's out of order, Chairperson.
Commissioner Malema is still on the floor.
Yeah, but a
Let-
point of order is
let him
procedural.
speak.
It's allowed in a meeting. It's out of order. It's allowed to raise a point of order.
But the candidate, the acting Chief Justice, needs clarification on exactly what is it that is required of him, so that he directs his focus when he reads those letters to what is in fact at issue.
Chair.
And that was the point that Commissioner Mlambo was in the process of explaining. If you have or you want an opportunity to respond to whatever Commissioner Mlambo says, by all means. Thank you.
ACJ, let me leave this criminality. Let me leave it.
Okay. Thank you.
Commissioner Klaver?
Chair, I was actually checking if we have not exhausted the issue. My view is that we have exhausted the issue.
Yes.
Can I also
Thank you,
raise another
Commissioner.
question, Acting President? I'm just worried about the direction in which this discussion is taking. It has a potential to taint this process. I think the insinuation that is appearing from this conversation, it has a potential. I think all of us know that we are a country that is highly litigious in terms of the nature of our democracy. And my worry is that the direction in which this discussion is taking is making this process vulnerable. Thank you.
Acting Chair.
Thank you, Commissioner Moimang. Commissioner Nyami.
Okay.
Chair, I'm aligning myself with Honorable Kaba that we'll have our own time. We've exhausted the matter, not unless there's something extraordinary. So I'm aligning myself with Honorable Kaba that let's close this matter.
Yes.
Point taken, Commissioner Nyami.
Yes.
Is there anything?
Acting President, yes. Since I was one of the people who raised these issues, I just want to say from my side, I do not think that we should ask the candidate to supply anything else. I think for the purposes of the interview, what has come out is sufficient for us to debate the matter in deliberation. So I propose that we close it. Other people, it can be taken out with the correct agencies later.
Thank you, Commissioner Mpofu. Acting Chief Justice, I've got a few issues that I want to clarify with you before we conclude the interview.
Yes.
Earlier on, you mentioned that someone had prepared a list of the Chief Justices of the Republic from way back during the 1880s or 1800s. I undertook my own exercise, but I commenced from 1910 to 2021, and I came up with 21 Chief Justices, all of whom were men. But one thing which might be of interest to you is that Stratford CJ was a Chief Justice for only a year, 1938 to 1939. But that was at a time when the Minister of Justice could pick up his phone and say, I'll be recommending you to be appointed as a Chief Justice to the President or State President. Then could we go to page 52 of Book 1 of 1, paragraph 16.
Is that paginated 52?
Yes, paginated 52, Acting Chief Justice.
Yes.
Where you deal with the subject of women in leadership position in the judiciary.
Yes.
And the proposition that I want to put to you is that if one takes that ideal to its logical conclusion, it must therefore mean that women must be given the same opportunities as men so that they too can reach the pinnacle in their judicial careers.
Obviously.
You have already been asked about the delays in the delivery of judgments in the Constitutional Court. And I will not
thank each and every one of you for this interview. I believe that we have exhausted issues. I don't think that there is really anything further that I would like to say. We have discussed the whole day. It's something to 9 o'clock, 10 to 9 o'clock. You have got my documentation in front of you. I just want to thank you for this opportunity. Thank you very much. I may say on a lighter note that whatever happens, this is the last time I appear before this commission as a candidate. I will never appear again. So, Commissioner Malema, you will never get a chance to ask me questions again. But on a serious note, I really thank each and every one of you, and thank you, Chairperson. Thank you, everybody. Thank you very much.
Thank you, Acting Chief Justice, and my apologies to you that it has taken us until now to conclude today's session. According to our schedule, we should have been done by 4 o'clock this afternoon.
Yes.
I thank you most sincerely for availing yourself and for your answers, or candid answers to the questions that were put to you by the members of the Commission, which will no doubt be taken into consideration during our deliberations. So you are now excused, Acting Chief Justice. Thank you very much.
Thank you very much, Chair. Thank you very much, Commissioners. Thank you.